May I mention a matter, my lord?
Yes.
Item number 71, I have challenged a charge sheet. After the writ petition was served upon them, they have issued an email that I have to file my defense statement by 11th of January, my lord, or my case will be closed. If your lordship takes up any day,
Let it continue. Ultimately, if it is found that this initiation is wrong, then court will pass an appropriate order.
may I intimate them that lordship
Matters-
direct the matter to appear on any day and not
appearing as item number 71.
71.
The supplementary list, it is there.
It is there, lordship. Some little
No, there is
upgradation.
no further upgradation is not possible. Mr. Sarkar.
Well, may I communicate to them that item appearing as item was 71, you are requested not to proceed with the matter.
That court is not going to advise you.
Lordship. Deeply obliged.
Item number 1.
My lord, 1 minute, I am for the petitioner, my lord.
We are for the respondents.
My lord, so far the petitioner number 4.
PSF complete, CISF complete. আচ্ছা
এই নাম্বার
ও
বলে দিচ্ছি এই দেখুন
এই আস্তে আস্তে দিচ্ছে আর কি মানে রূপনাথ রূপনাথ করবে কিছু করার নেই শুনতে হবে লোকগুলো এত ফালতু করবি এসএসসি সব কমপ্লিট করে দিয়েছে
Yes.
my lord, so far your lordship's order dated my lord 13th November 2025, your lordship directed the SSC to publish the revised list within 7 days from your lordship's orders, my lord. My lord, I have duly communicated with lordship's order. My lord, so far the petition number 4, 14 and 15 are concerned, my lord. As of date, my lord, their revised result has not been published, my lord. And last occasion, on behalf of the my lord Union of India, they have stated that everybody's name has been sent before the my lord SSC for revised result, but that has not been my lord done as of date, my lord.
এদের নামই পাঠায়নি এসএসসি
ডিপার্টমেন্ট পাঠিয়ে দিয়েছে সব, এসএসসি ধরে বসে আছে।
এখানে 50 জন আছে না টোটাল কজন হ্যাঁ আচ্ছা তার মধ্যে 3 জন বাকি আছে
Yes, revised list, Mr. Bajpai.
My lord, my information is that SSC has forwarded all the names, those who were found eligible as per the forensic report. Maybe 2-3 persons is still awaited, but out of 50 total candidates, most other candidates, CISF has completed more or less 9 candidates. And everybody...
You are taking steps and it is recorded in the order dated 11 December 2025 that out of 18, 6 petitioners have already been appointed and 3 are awaiting for appointment. Now 3 were awaiting appointment. Now the 9 other candidates are still 9 candidates are left.
Yes, they are.
If you publish the revised list,
Yes.
then everything will be clear. A
No, my lord,
transparency
we
can
have
be maintained.
we have published the revised list.
Where is that?
From my learned friend's statement, my lord, I find that 3 are left. So, my lord,
You
these,
publish the revised list to maintain transparency. Those who are left in the revised list, those who are in the revised list, their candidature is to be considered.
that is that is my instruction is, my lord, that this has been given, but the question is total 50. But the
My lord, thing is this, my lord, they publish the
maybe
revised list
one
in
or two.
respect of the candidates concerned, my lord. My lord, when the, my lord, entire, my lord, dossier has been sent before the SSC after completion of CFSL and all these things, my lord.
BSF, CISF has. Sorry. Process is on, my lord. Anytime. এই দুটো কি তোমার?
এটা কি বলছে? Regarding forwarding of complaints from courts to organs. কি বলছে?
So this is the revised list according to
Revised list.
there are
So,
54 candidates.
54
You give a copy to to the learned advocate.
Yes, but I find that one or two names are yet to be forwarded, as per instruction. So, my lord, the process is on. With deepest respect to your solemn order of your lordship, my lord, we are actively in the job. My lord, the question is, my lord, maybe 2 or 3 are delayed for some other reason. My lord, I am not acquainted with that, my lord, till
No,
now.
after completing the process, please publish the revised list,
Yes.
including the those withheld candidates. Those who are found to be eligible.
Yes.
My lord, may I?
That is 54 candidates.
Yes. Then if it is the final revised
So
list,
out of 54, my lord,
disclose the same and bring it on record by filing a report in the form of affidavit.
my lord.
If it is the final revised list,
Yes.
but you are submitting the still 3 or 4
2,
candidates.
3 candidates are
So they are to be
still
included.
awaited, my lord.
They are to be included in the revised list.
Yes.
So then the number of candidates in the revised list will be increased.
There are different categories, my lord.
Yes.
SSB, CISF, BSF. These are the categories, my lord. So all are to be clubbed together and then to file a report, my lord. So, my lord, if
Whether
you
the petitioners are within the under the same category? No.
same
My
category.
lord, in this, my lord, so far the petition number 4 and 14 and 15 are concerned. Both are, my lord, 14 and 15 are from CRPF category and 4, my lord, BSF. My lord, all the dossiers, my lord, that is CFSL and all these records has been sent before the, my lord, SSC for revised result. My lord, last occasion they have submitted that from the end of the, my lord, recruiting authority, they have completed all these things. They have sent before the SSC for revised result so that the appointment letter can be issued. That's why your lordship directed on 13/11/2025 to the SSC to publish the revised result, my lord, on the basis of the submission made by the Union of India, my lord.
From the department, it has
My lord,
been
so
sent
far the other candidate, they are, my lord,
been
revising
sent to
result
whom?
part wise.
From the department it has
to
been sent
SSC. SSC.
To
Now
SSC.
SSC is in the process to.
SSC is sitting tight over the matter.
let SSC publish a revised list. This is
Right.
not a revised list published by SSC.
No, it is the department's list.
So you are also representing SSC, publish a revised list.
All right, my lord, in that event, my lord, I will file a report with
No,
the
no,
public.
first place it before this court, the revised list. 7 days,
My lord,
ask your officers.
my lord.
That will make the everything clear.
Yes.
7 দিনের মধ্যে SSC
And all the candidates are fit for election.
পাওয়া যাবে? They are asking a week's time more, my lord.
Very well, fortnight time you take and publish the revised. SSC to publish, SSC's party.
Yes, yes.
SSC to publish the revised list.
Yes. Staff Selection Commission.
Yes, yes, party regional director, my lord.
Issue. Matter is heard in presence of the learned advocates representing the petitioner and Union of India. Stop. Next paragraph, it is pointed out by the learned advocate representing the petitioners that in spite of order passed by this court on 13 November 2025, Regional Director, comma, within bracket, Eastern Region, close bracket. Staff Selection Commission,
এগুলো ঠিক আছে।
being responded to, was directed to revise list within a particular time. But till date, such revised list is not published. Next paragraph, it further appears from the submissions made on behalf of the parties that all materials which are required for publication of revised lists are now lying before the concerned authority of Staff Selection Commission. And as such, it is found there is no impediment in publishing revised list. Stop. Next paragraph, Mr. Bajpai, learned advocate representing Union of India, has prayed for fortnight time to publish revised list. Stop. Revised list in terms of the previous order passed by this state. Next paragraph. Regional Director, comma, Eastern Region, comma, Staff Selection Commission, being responded to, is directed to publish revised list by fortnight from date. Stop. List the matter under the same heading for further consideration on 29th January 2026. Take it back. Next.
Item number 2.
And for the petitioner, well, pursuant to my lord's last direction, we had communicated to the Kolani Ames, my lord, regarding examination of the petitioner with regard to DNS, my lord, and this report has come. My lord, this is my lord, we have not opened it.
Just a minute.
So the report was supposed to be sent to the court, not to the petitioner's lawyer.
That's true. Affidavit of service
It
file.
is absolutely sealed in. This is the final which I have received. my lord. Sealed আছে দেখে তোমাকে বলছি অফিসারদের কথা
এটা খোলো।
But we have no information about anything. We have no information about anything.
About?
About anything, any report, anything, whether he had gone there.
You are not required to get any information in terms of this order.
They were supposed to file the report before my lord.
Let me go through the report first. Now, in the review medical report, it was a case of nasal septum.
Deviated nasal septum, my lord. My
Your review medical examination is at page 32.
page 32, my lord. My
It tallies with the report furnished by other authorities. That the nasal it is not a deviated case of deviated nasal septum.
May I have a copy of the report, my lord, and take instruction and come back?
What instruction you will take? A copy will be supplied to you. Go through the report. Last
But I
part.
am not an expert. I
No,
don't
it's not
understand
required.
this, my
It does not require any medical expert
But
to
allow me
understand.
to
Sorry,
allow me to take an
go
exception.
to the report.
But I will not be able to understand this.
If you want to, I am ready to grant you opportunity to
Yes,
go through the
kindly
report.
grant me that.
But it is not a case of nasal septum as per Ames
But
Collen.
allow me to have a report, take instruction and come back.
What instruction you will take
But
further?
allow me to take,
Are you interested to go through the report or not?
obviously I'm
Please
interested.
go through the report.
But I'm making one submission before my lord. My lord,
Yes.
kindly
That
appreciate
does not mean that all submissions are to be accepted if it is not reasonable. Yes.
What can I say?
If you don't have anything to say, don't say anything. Yes.
But I am
go to the
a
report.
lawyer. I want to
It
take
is
this.
Ames Collen is saying that the nasal septum is at the middle.
Well, let
See
me
the last
sit
part.
with my client and come back with this. I cannot understand what is written there. Even from 32, I cannot
It's
figure out
absolutely
what-
clear. For that, no medical
Lord,
expert's
your-
opinion is
Your
necessary.
lordship,
There, since
your
court
lordship,
since here this court first, since this is court is not a medical expert, is not a medical expert, court That's why directed a central hospital to examine the petitioner medically and furnish a report. The central hospital AIIMS Kolani is saying that petitioner is not diagnosed with deviated nasal septum.
Very well. Let me have a copy of the report and come back. Let me have a
Yes,
copy of the
please
report
give
and
it to
come back.
me.
But I should get a copy of the report, Lord.
Yes, you will get a copy.
Let me come back with this.
Sure.
Not kindly appreciate this. Kindly, before passing the order, my lord will kindly allow me to come back with the
No
instruction.
further instruction is required. Sorry.
Not kindly record then my submission that I am praying for a
Yes,
leave
yes.
so that I can
That
take
I
an
am
exception to this.
Yes.
Lord, I am not a medical expert. Lord, your lordship is dealing with that, Lord, various matters. Allow me to come back on this. I should get a chance to
What
go
are
through
the
the
reasons?
report.
Only deviated nasal
Deviated
septum.
nasal septum.
Come
My-
to page
Page
32.
32, my lord. Deviated nasal. My lord,
It's not readable.
Maxillary
maxillary
sinusitis.
sinusitis with mild DNS
Then
with ancillary obstruction present.
something written there.
Whatever
DNS
I have
to
not seen a report.
DNS2, then something is written, it cannot be read. I can't read it.
Specified in the previous order with what regard examination is to be conducted. In the last order, it was already specified.
And no feature of sinusitis.
And
Maxillary sinusitis with এটা কি?
mild
Mild DNS also with auxiliary obstruction.
In terms of the order dated 10th December 2025, a medical board was constituted comprising 4 medical experts headed by head of the department ENT and HNS by the concerned authority of All India Institute of Medical Sciences within bracket AIIMS close bracket colon. And the said board examined the petitioner on 26 December 2025.
This is with mild
The
DNS.
report is
Right
prepared as
side
contained in
and
memo dated
auxiliary
26
obstruction.
December 2025.
Guidelines. Provision number 9C3D. Guidelines এটা কোন গাইডলাইন? মেডিকেল গাইডলাইন্স 2015 9C
Well, my report is prepared containing 2025. Which is placed before this court. না, a report is prepared, তবে কি বললাম?
Lord,
Signed by 4 members of the medical board. Stop. Said report dated 26 December 2025 is placed before this court in a sealed envelope by the learned advocate representing the petitioner. As the report was forwarded via memo dated 27 December 2025 or via letter dated 27 December 2025 by the Deputy Medical Superintendent -1 AIIMS AIIMS Kolani. Stop. Said report is along with forwarding letter dated 27 December 2025 and office order dated 22nd December 2025 are taken on record. Stop. Copies. Stop. Copies of this report, copies of the medical, copies of a report dated 26 December 2025, along with letter dated 27 December 2025, and office order dated 22nd December 2025 are to be supplied to the learned advocates representing the petitioner and Union of India by 9th January 2026. Stop. List the matter under the same heading for further consideration on 19 January 2026. Come back, go to the.
Lord, allow us to take a small exception in the meantime. But in the meantime,
Certainly not.
if we have to something to say,
Sorry.
Lord, we'll bring it on record.
No, it's
My
not
Lord may
required.
reject that.
You go through, come back.
Or my Lord may reject our
Please
statement.
call the next matter.
But I have a right to take an exception.
Please call the. It's
But I
not
have a
an,
right to take
it's
an
not an
exception.
statements made by the petitioner on.
Lord, we also have a medical board.
Sorry.
Lord, you also record that. Lord, kindly record and reject that. Kindly record and reject that. Kindly record and reject that. I'm praying for an exception. Reject that. Lord, your Lordship has a right to reject.
When I will pass an order, you remind me, I will record it.
Lord, today, then
Yes.
on 19th,
Please
I will
call
not
the
get
next
that
matter.
opportunity.
Item number 3.
Lord, on 19th, I will not get that opportunity. Kindly allow me to do that.
Sorry.
Lord, I'm making a submission. My Lord will kindly record that. My Lord, reject it.
Nothing is required at a time of final.
Lord,
hearing.
I am making a submission which will affect my client. Kindly record that.
No, not today. Sorry. This is not the time to
Lord,
record.
this will
order.
affect the ultimate order. It will go against us. Kindly
Yes,
record that.
That court will consider at the time of passing final order. Go through it, make your submission.
Lord,
If
I want to file an exception. My Lord will reject that
submission is found to
exception.
be relevant, then court will grant you further opportunity to make an exception, to file an exception.
Very
Not at this time.
I am so grateful to you. Lord.
Yes.
So grateful to you.
By my lord's direction. This
So
is
grateful to you.
what remains,
But I
my
am
lord.
only
My
Going through the report, if you make a relevant submission and which as per the assessment of this court, which
Absolutely.
if it is found that further exception is required,
I'm so
court will grant you opportunity.
My
party has already.
So don't waste court's time in this.
But I am
Please-
not
please
wasting.
call
But
the,
I'm so
next
My lord, only players and one post be kept, my lord.
No, not necessary at this
Already
stage.
input has been given, which shows, my lord.
Not necessary at this stage. Still appointments are continuing. Yes.
Item number 3.
Yes.
এই রিপোর্ট গুলো ওই 3টে পাতা জেরক্স করে দুজনকে দিয়ে দেবে, কালকের মধ্যে দিয়ে দেবে।
Yes.
In this matter, my lord, the penalty was imposed in a disciplinary proceeding, my lord, where no inquiry report was supplied. The last occasion, your lordship.
My lord, yeah. Yes, I know your lordship has called upon me to take instruction whether inquiry report was supplied to him or not. To this, my instructions are, my lord, that it was a proper inquiry which was being conducted. Disciplinary proceedings was conducted. He was given opportunity to cross-examine the witnesses. He had gone through the inquiry report. But since there are 3 types of punishment, my lord, minor punishment, major punishment, and take out together. And we take, my lord, एक minute. And my lord, and petty punishments.
Yes,
And the third one is the petty punishments.
petty penalty.
Under section 148, my lord, there are 3 types. My lord, yes, I hand over your lordship the book. And Now, my lord, 148 of the chapter 12 of the Railway Protection Courts rules, my lord, provides for 3 different types of punishment. One is the major punishment, dismissal from service, which shall ordinarily be a disqualification for future employment under the government. B, removal from service. C, compulsory retirement from service. Reduction
Here,
in
the punishment is withdrawal of incremental benefits.
Oh, no, only non-cumulative for 6 months. Only this much. D, reduction in rank or grade.
Reduction of loss.
So, my lord, it does not come within the ambit of
Relevant rule is 148.3.
Yes, I'm coming to that.
Minor
Minor
punishments.
punishment reduction to a lower stage in the existing scale of pay. My lord, he has not been reduced to a lower scale.
Withholding of next increments.
Withholding of next with or without corresponding postponement of subsequent increments. So, my lord, it is without postponement of subsequent increment. My lord, it is non-cumulative.
Where is the punishment?
Well, punishment order is, my lord, in page number 61.
60.
60. Page
60.
number
Just a minute. Yes, I ordered him punishment with 1. After Yes, it comes under 148.3
Yes.
B. Withholding of next increment with or without corresponding
Yes, it comes within
postponement of subsequent increments.
Yes. So, my lord, there are different procedures for the major and minor punishment. We don't talk about the petty punishment.
Yes.
So, my lord, kindly come to
এই এখানে রেলওয়ে প্রোটেকশন ফোর্সের ইয়েটা বার করো তো রেলওয়ে প্রোটেকশন ফোর্স অ্যাক্ট 1957 দেখো আছে এরকম বই ছোট বই Yes, 148.
yes, my lord. it comes
For
within-
148.3B,
There is a
what is the
different-
procedure
Yes.
contemplated?
Yes, first, my lord, kindly look at the procedure for imposing major punishment.
Yes,
It is given in Rule 153.
just a minute. 148.3. Rule
53. Separate procedure is laid down for major and minor. Now, my lord, why I'm showing this, that distinction has to be made between the major punishment and the minor punishment. Without prejudice to the provisions of the public servant.
153.
153.
Just a minute. Yes, 153.20. Yes, procedure for imposing major punishments. Major punishments is not.
It is not major punishment.
It's not a major
What
punishment.
is my learned friend is contemplating
Minor punishment, yes.
within the major punishment.
For me, the procedure for minor punishment.
Yes. Because, my lord, then, my lord, in major
Where is the procedure for minor punishment?
158.
158.
Yes.
Yes.
158. Rule 158. Procedure for imposing minor punishment. The disciplinary authority may impose any of the minor punishment provided in sub-rule 3 of Rule 148 and in Rule 149 after. I had shown to your lordship Rule 148.
After informing the
Then we don't kind.
Just a minute. But 158.2 is important.
Lord, 1.50.
158.2.
158.2. Whether, my lord, now we have to examine. Whether this case
Notwithstanding
comes.
anything content, please read it.
Yes, I'm reading it. My lord, whether it comes within this. I mean,
Yes.
it is not said that inquiry has not been conducted. In fact, he has been given opportunity to adduce evidence also. But even then, my lord, does come.
First,
I'll
read
show you.
158.2.
Yes, I'm aware, Lord. Notwithstanding anything contained in clause A of subrule 1, if it is proposed, after considering the representation, if any, made by the party charged under the said clause, to withhold increment of pay, and such withholding of increment is likely to affect adversely the amount of pension payable to the party charged. Lord, it is a case where, my lord, his pension is not going to be affected.
Why you are saying that
Yes,
pension
it will
is
not,
going to
because it is
affect?
non-cumulative. It is non-cumulative. So it will not be done. It is not going to affect. Secondly, my lord, kindly see. Or to withhold increments of a pay for a period exceeding 3 years. It is not exceeding 3 years. In one case, it is 6 months. In other case, it is 2 years. Or to withhold increment of pay with cumulative effect for any period. It is not cumulative. Or to reduce him by more than 3 stages in his scale of pay. All these 4 things, my lord, does not apply at all. An inquiry shall be held as far as possible in the manner laid down in Rule 153 before making any order imposing on the party charged any such punishment. But if these 4 situations are contemplated, my lord, then an inquiry as proposed under Rule 153 would apply.
So therefore, 158.2 is not attractive
158.2 is not attracted at all.
because it is for 2 years
And
with
6 months.
non-cumulative effect.
Non-cumulative effect, and pension will not be affected. His increment, his promotion will
Now,
not be
if
affected.
court proceeds on the premise that if it is a case where 158.2 will apply, 158.1 will apply.
Yes.
In that event also, it is provided under 158.1A that informing
Yes.
the enrolled member of the force charged in writing of the proposal to take action against him and of imputation of misconduct or misbehavior on the basis of which action is proposed to be taken and giving him a reasonable opportunity of making such representation within a period of 10 days from the date of communication as the case may be, as he may wish to make against the proposal.
Yes.
taking the representation, if any, submitted by the party charged under clause A into consideration and recording a finding on each imputation of misconduct.
Yes, my lord, this is correct.
Now, whether this procedure is
This
followed.
was complied with. Even, my lord, the witnesses were examined. He had also adduced evidence. He had
You are
gone through
granted
the
opportunity to
document.
make representation.
Yes, yes,
My lord,
I
kindly
shall
see-
show. I
kindly
have got the
kindly
record.
see. I'm coming from the commencement of this proceeding.
Yes.
Right, initially,
My lord, let me show to
show cause
you.
notice in page number 27. Kindly see.
अच्छा अच्छा क्या next
Show
देखा
cause
था?
notice.
हाँ, वो तो
Show cause
representation
notice
दिए
is
थे.
page number 27.
I'll start off now.
Thereafter, my reply.
This is the show cause notice.
Page 26.
27 is the show cause
20,
notice.
20.
Page 27 is the show cause notice.
Yes.
From which writ petition you are showing? There are two.
62.
This is the show cause notice, page 27.
Yes.
And your reply?
Reply is page number 30.
30.
30. P5 month.
हाँ,
P5.
Made reply for each
30.
allegation.
वो तो पता ही है.
Then
My lord, after this, and my lord, kindly come to page number
the
34.
requirement is information informing the enrolled member of the force charged in writing of the proposal to take action against him and of imputation of misconduct or misbehavior on the basis of which an action is proposed to be taken, and giving him a reasonable opportunity of making such representation within a period of 10 days from the date of communication as he wished to make against the proposal. Taking the representation, if any, submitted by the party charged under clause A. Body. The proposal along with imputation of misconduct, response to such proposal and imputation of misconduct, and taking representation if any submitted by the party charged under into consideration, recording a finding on each imputation of misconduct and misbehavior.
Yes.
So where is the proposal?
This is the proposal. Kindly see page 27. He was called upon to show cause.
The show cause.
Page 27.
Yes,
27 show cause.
show cause. In terms of 158.1A.
Oh, this is not. This is the proposal along with
Yes.
along with imputation of misconduct.
Yes,
Page 27.
27.
Which petitioner is saying show cause,
So cause.
and then the reply of the
Reply
petitioner
is
is
at page 30.
page
30.
30
Fifth
is
June
the reply.
2000.
But court was proceeding on the premise that there was no inquiry, no hearing,
No, it is not correct.
there was no independent inquiry by independent inquiry officer, and no opportunity of hearing was granted.
Yes.
But that is not the requirement under
But kindly see.
considering the nature of charge.
Kindly see.
Considering the nature of charge,
Yes.
that is not the requirement under 158.1 AB.
Kindly see page rule 158 is a procedure for imposing minor punishment.
Yes.
Then 151, 158.1, 158.2. Then my lord, kindly come to 159. That is departmental proceeding file. My lord, this file containing these things:
It is
order
there.
sheet, preliminary papers, charge, statement of prosecutions.
Yes, it is all
But it
there.
pros-
That is in
Prosecution's
respect of major punishment.
Not even in this also we have maintained it. In this also we have
Well,
maintained it.
In the chart sheet, it has already been stated that they have taken
No, it is
that I am not innocent.
since it is at the motion stage.
Yes.
Court found that there was gross anomaly on the face of it, and court was under the impression that this punishment order requires to be set aside. Now, after hearing Miss Manoth, it appears that they are considering the nature of charge as contemplated under 148.3, which is minor punishment. Now, authority is required to follow 158.1. Now, if it is a case of following the procedure as contemplated under 158.1, then issue needs to be decided on exchange of affidavits. At the motion stage, the issue straightway the writ petition cannot be allowed. They have to file their reply in order to opposition in order to demonstrate before this court that they have complied with the procedure.
But one thing, my lord, in case of
I was under the impression that there was no inquiry, there was no opportunity of hearing,
Yes.
and straightway and punishment was imposed, but that is permissible in terms of 158 since it is a case of withdrawal of increment for a period of 2 years
in case of
without cumulative effect.
my lord, in case of minor punishment also, my lord, a right to hearing and the
Has been given, my lord.
and there is a violation of natural justice. But I am relying on small judgments. If your lordship allow me to permit me to
But I shall.
No,
if your lordship.
court has to consider based on 158.1.
This is also minor punishment.
That is the rule is there.
My lord,
Here it is a rule.
but Supreme Court
Don't
says,
file your affidavit. Sorry,
Well,
not at this
your
stage. It's
lordship,
not.
my lord, kindly allow me, my lord, to submit my the judgment.
File for let the materials be placed.
I shall
Because I was under the impression that this the full-fledged disciplinary proceeding is required to be initiated. That
At
is not
least, my
the
lord,
prescription of law.
your lordship, my lord, kindly see. If your lordship kindly see my reply, where my lord I have my lord enclosed some statements. Those persons required to be my lord heard in the examined in the proceeding. Kindly see the statements of several persons. 70. My lord, kindly see page number 31. Also, my lord, second paragraph. Also, in his statement, he established that my 17 eyewitness statements are correct and true in all respect, but he falls all the statements written into the above referred explanation preferred by IPF come inquiry officer such and such. Categorically, he falls the statements written when there is a wrong English into the said explanation. See such and such, such and such, such and such. So these persons part has to be examined. Ought to have been examined. Further, he added into his statement such and such had deliberately added some extra things into his statement which is other than the statement of Sri such and such, and on being asked to give one copy of the statement. So I've annexed the statement. Those persons required to be my lord examined.
You have given the statement. Statement.
Then I have collected the voluntary statement of such and such, in which he established that my 17 eyewitnesses' statement are correct and true in all respects.
Is
I
there
have
any
got-
appeal provision? Is there any appeal provision against this?
Yes, my lord.
Appeal,
He has
there are-
preferred appeal also.
You have
Yes.
availed of appeal
Yes.
provision.
Appeal
Yes.
revision also.
Appeal revision, everything is. क्या बोल रहा
My lord, before submitting charge sheet, there was no hearing at all.
है? My lord, in fact, in appeal, the period was reduced in one of the case.
Reasonable opportunity of making such representation. But in case of
My lord, in the chart sheet, my lord, if you
major punishment,
my lord, but kindly see the chart sheet itself. They have my lord, stated that I am not innocent. In chart sheet also they have, I mean,
there is a
no
procedure of
accusation.
imposing major punishment.
Yes, that was what I was showing you, Lordship, 153.
153.
Yes.
See, you are trying to build your case
Well.
based on 159. As it is stated that every departmental proceedings file shall contain
Yes,
this document.
every, my lord.
So therefore, whereas the statement of written statement of defense, then findings of the
statement of
inquiry
defense is
officer,
there.
then order of the discipline authority,
My lord,
then the defense statements of guilty and not
Yes.
guilty, prosecution. Don't make your case based on this based on the provisions as contained under 159, because 159 is contains provisions which relates to maintaining records,
my lord, kindly see.
which relates to maintaining records.
Right.
But you are trying to make an inferential conclusion based on 159 that each and every disciplinary proceedings must contain statement of witnesses, then the findings of the inquiry officer. Now, if it is a case of imposition of minor punishment or petty punishments, and where Rule 158 suggests that full-fledged inquiry is not required, question of maintaining those documents relating to deposition of witnesses does not arise.
My lord, kindly see.
So therefore, don't start from the end.
I-
You need
I
to
obey
make
your-
out your case based on 153. Inferential process of reasoning based on 159 section Rule 159 is not permissible.
Lord, I bow down your observation, my lord.
Where 159 says that each departmental proceedings shall retain these documents. That is for maintenance of office records.
My lord,
Now, if it is a case of imposition of minor punishment, where full-fledged inquiry is not required, only consideration of your representation is required, and returning of finding by the disciplinary authority against each allegations. Then the question of maintaining records containing depositions of witness does not arise at all.
your lordship, kindly come to the
So
punishment.
you are trying to make out an inferential
Let
process
me-
of reasoning
Give us 2
based
weeks
on
time.
159.
Let
I
me
bow down
file-
your lordship's
let me
observation.
file an
My
affidavit
lord, kindly,
within 2 weeks,
kindly
my lord,
see.
to come back disclosing
My lord,
all the
kindly just
documents.
one thing, my lord, I want
And
to just,
thereafter, my lord, because
page
it
number
will not
60,
be
they have the
useful
punishment order.
before
Kindly see.
affidavits 2 years.
And page number 60 of the punishment order.
Yes.
My lord, kindly see. My lord, fifth paragraph, accordingly.
কোনটা please?
Punishment order, fifth paragraph, accordingly, which starts from according. May I read, my lord? Accordingly, an explanation was asked from IPF, the petitioner. VD office number, office order number such and such. But it is astonishing that in the explanation, specific points were raised in the conclusion, but he did not bother to submit any clarification or did not enlighten or to produce any evidence, my lord. My lord, I have given the evidences, the copies of the statements. So, my lord, those persons required
Kindly
to be
see, he has
taken
conducted an
into
inquiry
consideration
himself. He has
to
obtained
prove
the
his
statement of
innocence.
various
In the
persons
case,
and annexed it.
rather,
This
submitted
inquiry was supposed to be done by the,
very casual and lame explanation, and he has conducted an inquiry himself without the order of the higher authority. But those person, the statement of those person, when I produced, those person ought to have been taken into consideration.
you cannot take a statement. You
But
could have asked the
in
authorities
this
that these
ground, my lord,
statements are
my
required.
punishment was imposed. And in the last paragraph also, my lord, I have carefully gone through the defense representation with pros and cons, but not convincing with the reply submitted by
Order of the appellate authorities is at page 69. And the revisional authority is at page 83.
well,
Issue. Matter is heard in presence of the learned advocates representing the parties. Stop. In the writ petition, order of the discipline authority dated 19 July 2024, which was 19 July 24 and and Takeda, order of the appellate authority dated 13 December 2024 and order of the revisional authority dated 24th May 2025 are questioned. Order of the discipline authority was modified by the order of the
Yes.
revisional
Yes.
authority.
Yes, please.
So
It was reduced.
it was withholding of next year, withholding of next increments for a period of 2 years.
Which was
No.
reduced to 6 months.
reduced to 6.
6 months. Stop.
And you also will find that he has conducted.
Proceeding
parallel
which was
inquiries.
initiated against the petitioner was culminated into an order of punishment dated 19 July 2024, whereby a punishment of withholding, whereby it was decided that petitioner to suffer withholding of next increment for a period of 2 years with non-cumulative effect. Stop. However, the divisional authority video order dated 24th May 2025 reduced the punishment and thereby directing that petitioner to suffer withholding of next increment for the period of 6 months without cumulative effect. Stop. Next paragraph, learned advocate representing Railway Protection Force on placing reliance on Rule 148 of the Railway Protection Force Rules 1987. Submitted the punishment which was decided to be imposed upon the petitioner is a minor punishment as contemplated under Rule 148.3.
148.3.
148.3, which does not require
The procedure to be followed in Rule 153.
full-fledged inquiry rather discipline authority is required to follow the procedure as contemplated under Rule 158.
Rule 158.1.
Stop. According to the respondent authorities, steps which are required to be taken in terms of Rule 158 were taken prior to imposing punishment upon the petitioner. Stop. Next paragraph. On the contrary, it is submitted on behalf of the petitioner
My lord, may I?
that petitioner was denied opportunity to present his case, and it's a case of violation of natural justice. Next paragraph. Issue needs to be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 3 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Stop. List the matter under the heading hearing in the monthly combined list of March 2026.
My lord, may I just indicate one thing? I'll kindly see rule 15.158.1.
No, it requires for
No, my lord,
detailed
I know.
consideration.
Just one thing, my lord, I just want to.
Yes, please, next matter, call the next one.
Identical, my lord. Here, my lord, the punishment was not modified.
এই ওটা দাও মার্ক করে রেখে দিই, পরে দেবে ওনাকে।
My lord, item 4, everything is identical, but here the
Item number 4.
authority did not modify the
আচ্ছা,
punishment.
দেখি ওই বইটা দাও তো।
And dates are also required to be changed.
Punishment is shame.
2 years.
But here, my lord, in explicitly said that inquiry report was not cannot be supplied. Kindly see page number 35.
Issue. আচ্ছা, এখানে দেবে ডেট অফ
But-
পানিশমেন্ট 29th of June, অর্ডার অফ দ্য ডিসিপ্লিন অথরিটি যেটা আছে, পরও অর্ডারটা আমি বলে দিচ্ছি। হ্যাঁ, 29 June 2024. Punishment order is dated, discipline authority's order dated 29 June 2024.
And the
29 June.
appellate authority is 6 December.
Just a minute. Appellate authority's order is dated
6th of December 2000.
page.
My lord, it is at page. My lord, 49.
হ্যাঁ, কি বলছে appellate 6 December 2024.
And divisional order is at page
61.
61.
dated 2nd
2nd May.
Here it is
2025.
not modified.
2nd May 2025. 2nd May 2025. It at 29 June 2024. Yes. হ্যাঁ, কিন্তু কি লেখা আছে বলো, ওটা চেঞ্জ হয়। সো অ্যান্ড সো। হ্যাঁ, না, এখানটা চেঞ্জ করো, এখানটা লাইনটা লিখো। order of the recipient authority dated 29 June 2024 was affirmed by the orders of the appellate authority and revisional authority dated 6 December 2024 and 2nd May 2025 respectively. তারপর one 58. Huh. Gross violation. Gross violation of justice. Yes.
But in the revision order, there is punishment was not reduced.
Yes, yes. That I have.
That has been recorded. Yep, yep.
You will get back the book after the office.
Yes. Good.
Item number 5.
We will only try to persuade my lord to hold up on going to the merit of the whole issue.
Just now, he was there. Where, my lord?
Let me complete my submission because it's coming. Hey, Joshua Chandra Kumar to the
Where is Mr. Dotto?
He was here.
He was here.
Yes, that
Yes.
I am. No, Chandra Kumar is with me.
I will just take your lordship 2-3 paragraphs.
এই এটা এটা রাখো এটা এখন থাকুক। Yes, just a minute, Mr. Bhattacharya.
That I will be referring from the Supreme Court cases, the paragraph begins like this.
Just a minute. Yes, Chandra Kumar.
Yes. We may first address the issue
Which paragraphs you are relying on?
90 from SCC.
Paragraph
90.
90.
The earlier paragraphs, the court decides the necessity of constitution of tribunals, whether the tribunals are subject to judicial review. These are all issues. Now, the basic thing. We may first address the issue of exclusion of the power of judicial review of the high courts. We have already held that in respect of the power of judicial review, the jurisdiction of the High Court under Article 226 and 226 cannot wholly be excluded. It has been contended before us that the tribunal should not be allowed to adjudicate upon matters where the validity of legislation is questioned, and that they should restrict themselves to handling matters where constitutional issues are not raised. We cannot bring ourselves to agree to this proposition, as that may result in splitting up the proceedings and may cause avoidable delay. If such a view were to be adopted, it would be open for litigants to raise constitutional issues, many of which may be quite frivolous. These are the important areas. To directly approach the High Court and thus subvert the jurisdiction of the tribunals. Moreover, even in these special branches of law, some areas do involve the consideration of constitutional questions on a regular basis. For instance, in service law matters, a large majority of cases involve an interpretation of Article 14, 15, and 16 of the Constitution. To hold that the tribunals have no power to handle matters involving constitutional issues would not serve the purpose for which they were constituted. On the other hand, to hold that all such decisions will be subject to the jurisdiction of the High Courts under Article 226, 227, before a division bench at the High Court within whose territorial jurisdiction the tribunal concerned falls, will serve two purposes. While saving the power of judicial review of legislative action vested in the High Courts under Article 226 and 227 of the Constitution, it will ensure the frivolous claims are filtered out through the process of adjudication in the tribunal. The High Court will also have the benefit of a reasoned decision on merits, which will be of use in a finality deciding the matter. The first will the screening the Honorable Supreme Court find the tribunals will ultimately weed out the dead issues, then decide which should be considered by the division bench in judicial review. Just consider the situation, Milord, when we moved before learned single judge under Article 26, when tribunal was there. The division bench was hearing the orders under appeal from the first court. First court was not here, the learned single judge under Article 226. Now this role of the first court is now being really transferred to the tribunal, constituted under Article 323. These are not the ordinary statutory tribunal. Then, it has also been contended before us that even in dealing with cases which are properly before the tribunals, the manner in which justice is dispensed with them leaves much to be desired. Moreover, the remedy provided in the parent statutes by way of an appeal by special leave under Article 136 of the Constitution is too costly and inaccessible for it to be real and effective. Furthermore, the result of providing such a remedy is that the docket of the Supreme Court is crowded with the decisions of the tribunals that are challenged on a relatively trivial grounds, and it is forced to perform the role of a first appellate court. We have already emphasized the necessity for ensuring that the high courts are able to exercise judicial superintendence over the decisions of the tribunals under Article 227 of the Constitution. In Arkajan's case, after taking note of these facts, it was suggested that the possibility of an appeal from the tribunal on questions of law to a division bench of the High Court within whose territorial jurisdiction the tribunal falls be pursued. It appears that no follow-up action has been taken pursuant to the suggestion. Such a measure would have improved matters considerably. Having regard to both the aforesaid contentions, we hold that all decisions of the tribunals, whether created under pursuant to Article 323 or 320b, will be subject to the High Court's writ jurisdiction under Article 226-27 of the Constitution before a division bench of the High Court within whose territorial jurisdiction a particular tribunal falls. Therefore, the decision of the first court, I am emphasizing this, always goes to the division bench. The initial Constitution was challenged on the ground that all would go to the Supreme Court. The Supreme Court, it will be burdening us. You cannot denude the High Court of its power of judicial review. Therefore, the division bench, any decision of the tribunal would be considered. Now, just visualize the situation, tribunal is not there. Functionally, why would the litigant go? The Supreme Court always was considering the necessity of the litigants to get justice, and then follows. We may add paragraph 92. Under the existing system, the direct appeals have been provided from the decisions of all tribunals to the Supreme Court under Article 36. In view of our above-mentioned observations, this situation will also stand modified. In view that we have taken no appeal from the decisions of the tribunal will directly lie before the Supreme Court under Article 136, but instead the aggrieved party will be entitled to move the High Court under Articles 226, 227 of the Constitution, and from the decisions of the division bench of the High Court, aggrieved party could move before the Supreme Court. The three-tier system remains. Only the first court is shifted to the tribunal, nothing else. Then, my lord, kindly come to below the paragraph 94. I am just skipping over 93. Directions issued by us in respect of making the decisions of the tribunals amenable to scrutiny before the division bench of the respective high courts will, however, come into effect prospectively, that is, will apply to the decisions rendered thereafter. Again, below the decisions. not, my lord, the question of, my lord, having approaching the court for at the first instance. Then straightway I invite my lords to come to paragraph 99, which is the concluding paragraph. In view of the reasonings adopted by us, we hold that clause 2D of Article 323A and clause 3D of Article 323B, to the extent they exclude the jurisdiction of the High Court and the Supreme Court under Articles 226, 227, and 32 of the Constitution are unconstitutional. Section 28 of the Act and the exclusion of jurisdiction, within quotation, clauses in all other legislations enacted under the aegis of Article 333 and 333B would do the same extent be unconstitutional. The jurisdiction conferred upon the High Courts under Article 226, 227 and upon the Supreme Court under Article 32 of the Constitution is a part of the inviolable basic structure of our Constitution. While this jurisdiction cannot be ousted, other courts and tribunals may perform a supplemental role in discharging the powers conferred by Article 226, 227 and 32 of the Constitution. The tribunals created under Article 323 of the Constitution are possessed of the competence to test the constitutional validity of statutory provisions and rules. All decisions of these tribunals will, however, be subject to scrutiny before a division bench of the High Court, within whose jurisdiction the tribunal concerned falls. Tribunals will nevertheless continue to act like courts of first instance in respect of the areas of law for which they have been constituted. Well, I will stop here. The final conclusion is that High Court's power of judicial review remains, but the tribunal will act as a supplemental, as a first instance court. Now, a division bench will only be available from decisions of the tribunal, not otherwise. Now, the decisions of the first court, Lordship may take this, would be available to the division bench. If the first court is not there, where if I straightway go to division bench, then I will be losing a forum. Both the parties, not only why the litigants will be losing a forum. And that's why.
And the power to exercise judicial review, as it was decided by the in L. Chandra Kumar in paragraph 90, 92, 93, that comes if there is a decision by the first authority or by the first forum.
Yes. If the first forum gives a decision, good but indifferent parties,
then the question of exercising power of judicial review will arise. If there is no decision of the tribunal vis-a-vis the decision of the first court or single bench, where is the question of exercising judicial review?
the first court originally without the lead court, without the judicial review before the first court. The litigant approaches the court for judicial review. Now, by amendment, without the power of the first court was shifted to tribunal, that is a supplemental. And any order from the first court, you don't have to go to Supreme Court. You have to come through the channel of judicial review of the High Court to division bench, because the High Court division bench initially had the power of judicial review from the first court's order. The first court, second court, then Supreme Court. Here the tribunal was constituted as I say supplemental. Supreme Court is very categorical, not substituting, supplemental. Now, if the first court is not available for any chance, what would be the approach of a litigant?
Whether the litigant cannot straightway approach the division bench of the High Court.
Because division bench
Taking a cue from the observations made in paragraph 90 onwards in L. Chandra Kumar.
90 says not the division from the decisions of the tribunal. The decisions of the tribunal means, Pilot, that tribunal had exercised its judicial conscience and have come to a decision. Like that, Pilot, if today, Pilot, if your Lordship refused to pass an interim order, Lordship had an applied mind, didn't pass interim order, parties agreed may go to the division bench. But the division bench cannot be approached saying that I have filed a petition. It cannot be, it's not a forum for you. Unless there is something, but indifferent, the division bench jurisdiction is barred by Constitution. And this is clarified by this L. Chandra Kumar while deciding the constitutionality of the constitution of these tribunals under Article 323 and B. that you are only giving a supplemental role at the first court to without the unnecessary litigation, so that the High Court becomes less burden. That was the purpose, and that's why we are following this. On the last occasion, I had cited T. Ranganathan, where the Supreme Court is very categorical. Then there is no tribunal, High Court would be the forum. No, that. This is administrative order to review. Now, anyway, my learned junior will not insist me to place paragraph 55.
55
That is,
of L. Chandrakumar.
I cannot ignore his Milord persistence. Here, Milord, he want to
Paragraph 50, page.
page 293. What is the judicial review?
Just a minute. Yes, paragraph 54. 55.
Henry Abraham, definition of judicial review in American context is subject to a few modifications equally applicable to the concept as it is understood in Indian constitutional law. Broadly speaking, judicial review in Indian comprises three aspects: judicial review of legislative action, judicial review of judicial decisions, and judicial review of administrative action. But we are approaching the first court for the judicial review of the administrative action. Now that review is now entrusted before the tribunal.
Yes.
Therefore,
Suppose there is a decision of the administrative action, administrative decision, you are affected by that decision. Then you
I
can
go to
approach the division bench for judicial review.
I cannot. I cannot approach division bench. Today, if I go to the division bench,
Because as per the definition as
no,
enshrined
these
in
are the areas. The areas, but it doesn't talk of forum. Whether the administrative actions judicial review is maintainable. It was not necessary, but since was insisting, therefore I approached the first court seeking judicial review. But this is not the appeal, the only judicial review of administrative action. I approached the court, and this first court was Article 226 court. Now, by tribunal constitution, they wanted to release the High Court from the burden. And the Supreme Court says the burden of dead wood cases, if I may use that expression, that many cases would be frivolous. They would be really burdening the docket of the High Court, and the areas would pile up. Therefore, the Constitution was, the Constitution empowered for formation of tribunal. The Supreme Court says, while upholding with reading down, that the tribunal would be supplemental as a first court.
against the decision of the tribunal review.
Against the decision of the tribunal, you have to go to division bench. You cannot come to the.
But in the present case, where is the decision?
There is no decision. We are acting by the administrative order. On merit, we may lose, we may be different thing. But somebody has to hear me. Who will hear me? Unless you are not.
There is no fast forum.
There is no fast forum. That's the point. And that's why both the division bench or court. What you have seen that Raghunathan? Yes. Now, I have last, just refer to your lordship. Kindly come to T.K. Rangarajan.
Just a minute. Paragraph 25.
Apart from the factual aspect here, it's very categorically mentioned. May I just read out?
Maybe I can.
Mute koro.
Finally, it is made clear that employees who are reinstated in service would take care in future. This paragraph 25 is now considering after the major issues were over. Then, employees who are reinstated in service would take care in future in maintaining discipline, as there is no question of having the fundamental legal and equitable right to go on strike. The employees who have to adopt other alternative methods for redressal of their grievances. For those employees who are not reinstated in service of the ground that FIRs are lodged against them, or after holding any departmental inquiry penalties imposed, it would be open to them. Now, these are individual employees, not for the thousands, to challenge the same before the administrative tribunal, and the tribunal would pass appropriate order, including interim order, within a period of 2 weeks from the date of filing of such application before it. It is unfortunate that the authorities concerned are not making the administrative tribunals under the Act functional and effective by appointing men of caliber. It is for the High Court to see that if the administrative tribunals are not functioning, justice should not be denied to the affected persons. In case the tribunal is not functioning, it would be open to the employees to approach the High Court. Now, when there was no tribunal, what did I approach? When you are at the bar, you're moving a motion not before the division. Moving a motion before the single bench, then appeal. Now, the right to move that motion before the single bench is now taken away to the tribunal.
But there are certain high courts, Mr. Bhattacharya, where there is no concept of moving a writ petition before a single bench.
There are few high courts that depends on their rules. But ultimately, hearing is made by the single bench. Well, I have had the occasion to argue with some admission stage like second appeal, they will do division bench. But once the writ is admitted, hearing is by the single bench. Therefore, after admission, the merit decided in single bench. From that, the appeal to the division bench. Therefore, admission will not is different concept, and will not the other orders will not pass by the single bench. That is the.
But in that event, this single bench of High Court will be transformed into a tribunal.
Because the tribunal.
Though there is a tribunal constituted under the Act.
Because I use the expression supplementing. Tribunal is supplementing High Court. High Court is not supplementing tribunal. Original power of jurisdiction with the High Court because of Constitution. Now, by parliamentary law, in exercise of constitutional power, not statutory power, you have created a tribunal which will supplement the High Court. Not High Court is supplementing tribunal.
এই বিরাজদার সাথে কনফারেন্স করিস না মামলা সভা পেছন থেকে 22, 23, 24 করছে হ্যাঁ
Now, your lordship had the occasion to dismiss the petition on the same ground by an order dated 15 December 2025.
কোনটা বিকাশ দা এটা নামটা বলুন তো অর্ণব অধিকারী ঠিক আছে অর্ণব
Yes.
Now, from that blood, appeal was taken and the appeal court was there.
Yes, yes. Which paragraph?
Paragraph 5.
আছে আমার কাছে এটা।
His intra-court appeal appeals the order dated so and so whereby the petition filed by the appellant is dismissed by holding at this stage or it is not maintainable. So and so, I am not troubling my lord.
তুই কি আইফোন থেকে পাঠাচ্ছিস
The single judge recorded that the West Bengal tribunal is not in a position to hear the matter because of non-availability of bench.
আমারও একই অবস্থা
Petitioners will be at liberty to take steps in accordance with law. In our considered opinion, this order dated 15 December 2025 cannot sustain judicial scrutiny for the simple reason that as a rule of thumb, It cannot be said that the recruitment process cannot be called in question for any reason whatsoever. Only after examining the grounds raised by the appellants showing illegality of the recruitment process, an opinion can be formed whether it can be entertained or not. Secondly, if the selection was pertaining to state government services, certainly its recruitment process can be called in question before the tribunal as per section so and so. The recruitment process can also be questioned before the tribunal. If tribunal was not functional, it was obligatory on the part of this court to hear the matter, otherwise the party will be remediless. Such a situation, my lord, where otherwise, suppose I give an example, very extreme example. Now, today I get a notice that your service will be terminated from tomorrow. You will stand terminated from tomorrow. Now, I have a right to approach the court for judicial remedy. I will rush to the tribunal. Tribunal is not constituted. I become remediless. Then I have to rush to the High Court. That's the point. And that's why, the Supreme Court in the L. Chandra Kumar watered down, they written down much saying, no judicial review would be available, but that should be the first court. And in non-availability of first court, makes me to get the availability of first court under inherent jurisdiction of constitutional power.
But in L. Chandra Kumar, in certain paragraphs, it is observed, I have read that High Court is not a substitute for the tribunal, or the tribunal is not substitute for High Court.
It's supplemental.
Now, a point is being raised before this court that litigants are losing a forum if litigants are directed to approach the division bench. In that event, a question of losing forum does not arise because High Court tribunal is not substitute for High Court or vice versa.
Tribunal is playing a supplemental role to the High Court. Like, I just read it once again. Lord, kindly come to me, Lord. It's important. Earlier paragraph, Lord, very
Paragraph 90.
yes.
Mr. Bhattacharya, please give me 5 minutes. Just come.
বিকাশ দা কতক্ষণ বলবেন? হ্যাঁ হ্যাঁ তো আমি
My lord, we kindly come to the paragraph 90 last.
Paragraph 90.
349, just taking.
Just.
What is my logic?
Yes.
To hold that the after the interpretation of Article 14,
Just,
15, 16.
just a minute. Sentence starts. To hold all such decisions.
Yes.
Yes.
On the other hand, to hold that all such decisions will be subject to the jurisdiction of the High Courts under Article 226 to 27 of the Constitution, before a division bench of the High Court within whose territorial jurisdiction of tribunal concerned falls, will serve two purposes. It will ensure, while saving the power of judicial review of the legislative action vested on the High Court and so and so. Therefore, my lord, the powers is saved, the power remains. Then it will ensure that the frivolous claims are filtered out through the process of adjudication in the tribunal. The High Court will also have the benefit of a reasoned decision on merits, which will be used to in finality deciding the matter. Therefore, the tribunal is constituted with a purpose to filter out the unnecessary matters. That too, saving the power of High Court intact under Article 226 to 27. And the Supreme Court says, if you get the first opinion, then you can straightaway go to the division bench for further scrutiny. There was some material judicial decision to be considered by the division bench. Here, my lord, the division bench gets material from the first court. We have no first court. That's the point. And that's, my lord, in paragraph 93 says that this is supplemental.
93 years.
Before moving onto other aspects, we may summarize our conclusions of the jurisdictional powers of these tribunals. The tribunals are competent to hear matters where the values of statutory provisions are questioned. However, in discharging the duty, they cannot act as substitute for the High Court. Therefore, the High Court remains his power, maintains his power. Supreme Court saying, cannot substitute for the High Courts and Supreme Court which have under.
Therefore, Mr. Bhattacharya, you are trying to point it out that if tribunal is constituted under 323 AB, then tribunal will function. But if tribunal is non-functional, the original power of High Court remains.
That's my point. And that's the decision. They say that however, in discharging this duty, they cannot act as substitutes for the High Courts and the Supreme Court, which have under our constitutional setup been specifically entrusted with such an obligation. Their function in this respect is only supplementary. All such decisions of the tribunals will be subject to scrutiny before the division bench of the respective High Court. But that's my simple. That's why our division bench also said, in different matters, that when the tribunal is not functional, you have no way out, but you have to approach the High Court, which is a constitutional setup. That was a helping hand to the High Court. Now, helping hand is not there.
In addition, there to in Rangarajan's case, paragraph 25, 2 lakhs employees were terminated. Now, some of them were directed to approach the High Court, tribunal. But there was one member in the tribunal. Then the Supreme Court felt that no, then
Justice cannot be denied, which is the fundamental for the.
Here the situation is acute that there is no member in the tribunal, including chairman.
But when tribunal is non-functional, in whatever way, in whatever form, I'm going to be detailed out. Therefore, my constitutional forum is available to me. So that's my point. Confusion. So, but division bench order, Lordship has had it, I think.
Yes, which order?
Division bench order, my lord, another order.
Justice Mukherjee.
Justice Mukherjee.
Give a copy.
Yeah, my lord, the division bench found that there is a single member, therefore it cannot function. Fundamentally, is that a forum for a litigant, my lord, cannot be made assured. But the constitutional courts are permanent. They were supplemental.
Yes, where is Mr. Dotto?
Mr. Dotto is coming, my lord. Just, yes.
May I take it?
Yes.
My lord,
এই এটাকে একটু খোলো না। Yes, you start, Mr. Dotto will join. Just a minute. হ্যাঁ, পরে আবার লাগিয়ে দেবো। কাটা আমার দরকার নেই, এখান থেকে খুলে দিতে পারবো।
আসছি, আসবে। ওই তো আরেকটা সময় নিয়ে গেলে তো ডাকতে বললাম। হ্যাঁ, বুঝছি। উনি একটু WPST অর্ডারটা একটু দাও। WPST যেটা যেটা এইমাত্র দিলে, কবি থাকলে একটা দাও না। এই যে হুম, বাবা, তো কথা বলে দিল। Yes.
In this matter, my lord, the West Bengal State Administrative Tribunal, my lord, it is not that it is fully, my lord, non-functional. It is partly functional. They are taking the, my lord, filing, and thereafter one date is being fixed by the, my lord, tribunal for
Whether any
hearing.
member is there.
But there is no member is not
Okay.
there. I am submitting before your lordship that it is not that it is totally not functioning. According to my humble
There is no member.
submission before your lordship, that if any aggrieved person file a petition before the, my lord, tribunal, state tribunal, and thereafter, since there is non-function of the due to there is no member in the, my lord, tribunal, therefore they should come to the High Court in the WPST. The forum is here. This is my humble submission and my
Yes, Mr. Dotto.
will say.
Now, my lord, access to justice cannot be denied. No dispute on that. Tribunal is functioning, but judicial functions are not being discharged or cannot be discharged
Because there is no member.
because there is no member.
I have also obtained a report through
Yes,
High
yes,
Court
yes,
that there is no member and chairman.
Justice Pal had retired, I think, in August 2024, and Justice Baba, I think, in September 2025. Thereafter, my lord, there is lack of member. Now, my lord,
What is the present position regarding filling up of
my lord,
those
till
posts? of this
last
tribe?
I knew, it was during Justice Sivagnanam's tenure, his lordship called me in a committee, but since I could not, according to me, I cannot remain in that committee, therefore I requested their lordships to exclude me. I was excluded. But the problem is, my lord, the rules provide that the outgoing chairman must be a part of the committee. Now, the outgoing chairman had retired in August 2024, therefore, he cannot be considered to be an outgoing chairman. But in any case, we requested Justice Pal, and he had accepted the assignment.
The position is stands still, so far tribunal is concerned.
But thereafter, but I do not know, but to the limited extent that I know is that some advertisement was published. Some of the honorable retired judges, district judges, they have applied. This much I know.
It is under the process.
Yes, but this I am talking about almost 7-8 months ago, my lord, this has happened. Maybe April or May, sometimes like that.
Now, what is your submission with regard to
Yes.
executing the sentence when the tribunal is non-functional?
Yes, but first is, my lord, we need to, my lord, my understanding, but I'll give the bottom line. My understanding is that it is not that the tribunal cannot be approached. How do we approach first? Even if in High Court, the approach is first in filing a petition before the department.
Yes.
That is available. Then, my lord, in the High Court, the files come to the respective courts having determination. And then, my lord, the judicial review happens. Here, this is not possible. Why? You can file it before the department of or the filing section in the tribunal, but in the absence of any member, it cannot be placed before the court. This is the impediment. Now this impediment has to be resolved. Resolved in a manner so that, number one, the litigants have the access to justice, or they are not denied justice because of lack of member, and at the same time, keeping in view, my lord, Article 323A
That is yes.
and Section 28 of the Administrative Tribunals Act, plus the restoration of judicial review by L. Chandra Kumar, my lord, whether it should be before a single judge or before the division bench.
Yes.
But that is what is to be resolved. I cannot say that so long the tribunal doesn't function, people will be denied justice. I cannot say that. But the question is, High Court being the forum, whether it is before a single judge or before the division bench. There, my lord, we need to consider.
This
There-
is the exact issue which this court is also considered.
Right. But I have a duty to assist your lordship in my own way, my lord. Here, my lord, I don't think, my lord, I am discharging the role of an adversary, but
Yes, yes.
primarily, my lord, to assist your lordship in my own way.
That's why court thought it fit to
Yes,
request you to
yes.
appear.
I hope, my lord, I live up to the expectations of the court. Well, please take, my lord, the constitution first.
Yes.
Article 323A. Well, I'll not trouble you with 323B because we are not with that.
Yes, no, that is different tribunal.
Yes. Well, sub-article 1 says Parliament may by law provide for adjudication or trial by administrative tribunals of disputes and complaints with respect to such and such. Therefore, administrative tribunals is an alternative institutional mechanism, not an alternative remedy. It is an alternate or an alternative institution sought to be set up in place of High Court. Now, where do we get in place of High Court?
It is not a case of alternative remedies simpliciter.
Right. Which is provided by a statute. Now, I have said that it is a tribunal created in place of the High Court. This your lordship will get from sub-article 2. A law made under clause 1 may, please take D, exclude the jurisdiction of all courts except the Supreme Court under Article 136 with respect to the disputes or complaints referred to in clause 1.
Except jurisdiction of Supreme Court.
So the law which the Parliament is competent to make under clause 1 can also exclude the jurisdiction of all courts except the Supreme Court. Now, only for comparison, please have a look to Miller 323B, just for comparison.
Just 323B. Yes. 2D.
Miller, I have placed 2D.
Yes.
Then
323A.
Yes, of 323A.
Yes.
But for comparison, please have a look to Miller 323B.
B.
The appropriate legislature may by law provide for adjudication of so and so, so and so, so and so.
Yes.
Then take please take Millard sub-article 3.
3.
The law made under clause 1 may, please take D, exclude the jurisdiction of all courts except the jurisdiction of the Supreme Court with respect to all matters such and such.
That is parametry of 2D of 323A.
Yes. Now, in both cases, your lordship will find
exclusion of jurisdiction of High Court.
Yes. Now, what is the difference in applying 323(2)D vis-a-vis 323(B)(3)D? Now, please have a look to Millard, section 28 of the Administrative Tribunals Act. এই কোথায় হলো?
এই ট্রাইব্যুনাল একটা দাও এখানে আছে।
এই এলআরটিটি একটাও তো দরকার, ওটা আনতে ভুলে গেলাম তো।
28 বললেন?
But if your lordship is having an LRTT Act, if your lordship may kindly take out, because I've forgotten to bring one. আছে কি LRTT Act? নেই না? একটু নিয়ে এসো না। ওই মানে ওয়েস্ট বেঙ্গল টেনেন্সি LRTT টা আছে ওতে? আমার LRTT দাও।
No, Mr. Dotto will rely upon LRTT, Land
I will
Reforms
do-
Tenancy.
but I'll fetch one book. Now, for the present, kindly have a look to Millard, section 28
Of 1985 Act.
of the 1985 Act. But Parliament is now applying its powers under 323A1. Exclusion of jurisdiction of courts except Supreme Court.
Just a minute, 28. Yes.
On and from the date from which any jurisdiction, powers and authority becomes exercisable under this Act by a tribunal in relation to recruitment and matters concerning recruitment to any service or post or service matters concerning members of any service or persons appointed to any service or post, no court except the Supreme Court or any industrial tribunal constituted under the so-and-so Act shall have or be entitled to exercise any jurisdiction, power or authority in relation to such recruitment or matters concerning such recruitment, such and such.
That is in furtherance to 323A to D.
So here, except reserving the power of the Supreme Court, all other courts' powers have been scuttled. The difference between 323A to D and 3D is that in 323, in
323
Tenancy Tribunal Act, but under section 8, the High Court's power in the division bench has been reserved along with Supreme Court.
Section 8.
Section 8, but I'll bring it and
Yes,
place it. But for the present, if I may only just read it for your lordship's consideration. Section 8 of the Tenancy Tribunal Act, which says that on and from the date from which the jurisdiction, power and authority becomes exercisable under this Act by the tribunal, the High Court, except where the court exercises writ jurisdiction under Article 226 or 227 of the Constitution by a division bench, or any civil court, except the Supreme Court shall not entertain such and such. So,
Power of division bench is saved.
Whereas under 323A to D, the entire High Court's power has been ousted. This is the difference. Now, keeping this in the background, now I'll make my submissions before my lord.
But Mr. Dotto, in both the cases, power of the single bench is not saved.
Right.
Even in case of 323A and 323B.
In both cases,
power of the single bench is not saved.
Whereas in Administrative Tribunals Act, the entire Supreme Court's power has been taken away.
So the single bench is in the same position on the anvil of 323A
as well as
B.
Right. Now, Milord, please have a look to L. Chandra Kumar.
Yes, L. Chandra Kumar.
State Milord, the first paragraph of L. Chandra Kumar. But I'll be very candid to your lordship, this point has not been dealt in details by any court. So the court has directed, like, go before the single bench, go before the division bench, but none of the judgments or orders that I find have not delved deep into it. That whether it should be the single judge or before the division bench. Now please take a look at paragraph number 1 where the issues have been framed. Issue number 1 is whether the power conferred upon Parliament or the state legislature, as the case may be, by subclause B of clause 2 of Article 323A or by subclause D of clause 3 of Article 323B of the Constitution to totally exclude the jurisdiction of all courts except that of Supreme Court under Article 136 in respect of disputes and complaints referred to in clause 1 of 323A or with regard to all or any of the matters specified in clause 2 of Article 323B runs counter to the power of judicial review conferred by the High Court on the High Court under Articles 226 and 227 and on the Supreme Court under Article 32 of the Constitution. Then 2 is whether the tribunals constituted either under 323A or 323B possess the competence to test the constitutional validity, because we are not concerned. And 3 is whether the tribunals, as are functioning at present, can be said to be effective substitutes for the High Court in discharging the power of judicial review. If not, what are the changes required to ensure? So issue number 1 and 3 with which we are concerned. Then if your Lordship may kindly directly come to paragraph 88.
88.
Yes, sir. But in R.K. Jain's case, it was first flagged as to how efficiently are these tribunals functioning.
But R.K. Jain's case was the ratio of R.K. Jain was not upheld in Chandrakumar.
Certainly. But R.K. Jain actually wanted that there should be an audit of the functioning of the tribunals. To what extent they have become effective substitutes.
Based on the report of Malimat Commission.
Yes. In R.K. Jain's case, this court had, in order to understand how the theory of alternative institutional mechanism had functioned in practice, recommended that NCI or similar expert body should conduct a survey on the functioning of these tribunals. It was hoped that such a study conducted after gauging the working of the tribunals over a sizable period of more than 5 years would provide an answer to the question posed by the critics of the theory. Unfortunately, we do not have the benefit of the study. We may, however, advert to the report of the areas committee that is made on the areas, then the functioning of such and such. Then I come to directly the issues from para 91. But I think portions have been read by placed by Mr. Bhattacharya.
Yes.
Para 91. It has also been contended before us that even in dealing with cases which are properly before the tribunals, the matter in which justice is dispensed by them leaves much to be desired. Moreover, the remedy provided in the parent statutes by way of an appeal by special leave under Article 136 of the Constitution is too costly and inaccessible for it to be real and effective. Furthermore, the result of providing such a remedy is that the docket of the Supreme Court is crowded with decisions of tribunals that are challenged on relatively trivial grounds, and it is forced to perform the role of the first appellate court. We have already emphasized the necessity for ensuring that the high courts are able to exercise the judicial superintendence over the decisions of tribunals under Article 227. In R.K. Jain, after taking note of these facts, it was suggested that the possibility of an appeal from the tribunal on questions of law to a division bench of a high court within whose territorial jurisdiction the tribunal falls be pursued. It appears that no follow-up action has been taken pursuant to the suggestion. Such a measure would have improved matters considerably. Having regard to both the aforestated contentions, we hold that all decisions of tribunals, whether created under 323A or B, will be subject to the High Court's jurisdiction under Article 226 before a division bench of the High Court within whose territorial jurisdiction the particular tribunal falls. We may add here that under the existing system, direct appeals have been provided from the decisions of all tribunals to the Supreme Court under 136. In view of our above-mentioned observations, this situation will also stand modified in the view that we have taken no appeal from the decision of a tribunal will directly lie before the Supreme Court under Article 136, but instead the aggrieved party will be entitled to move the High Court under Articles 226, 227 from the decision of the division bench of the High Court, the aggrieved party would move before the Supreme Court. Then 93 speaks about the virus part. I will not trouble your lordship with that.
That is not the issue here.
That is not the issue over here. And then will not directly 98 onwards, I think Mr. Bhattacharya has placed me. I'll not trouble your lordship with that. Therefore, what is the scheme? The scheme is that first create an alternative mechanism, institutional mechanism. Then excluding the power of judicial review of the High Court. Then the Supreme Court takes stock of the functioning of the tribunal. And the fact that the Supreme Court is getting overburdened with appeals directly from tribunal.
These were the considerations.
These were the consideration. And along with that, I have not placed those parts that may lengthen my argument. Supreme Court felt that judicial review is one of the basic structure of the Constitution. And that judicial review must also be restored before the High Court. And the Supreme Court felt that this judicial review has to be done by the division bench and not the single bench. Right. I agree, my lord, L. Chandra Kumar was not considering this kind of a situation in which, my lord, we are dilating before your lordship.
Now the question which comes up, which is troubling this court, whether in exercise of power of judicial review, the division bench can act as a first forum.
Yes. Then, my lord, I'll make my submission.
Yes, yes. You may.
No, I'll make the submission right now. My lord, Mr. Bhattacharya's argument is that High Court to exercise the power of judicial review must have before it the results of the tribunal in the form of an adjudication. That what prevailed with the tribunal to pass an order, which is absent over here. Or in other words, if somebody is asked to come directly before the division bench, then the division bench is not being provided with the facility of the application of mind by the single bench or the tribunal. But that may not possibly be, my lord, a correct view, because when power of judicial review is exercised, as that paragraph 52 or 53 of my lord L. Chandra Kumar, may I take your lordship back to that paragraph?
Yes, yes.
This judicial review are of three parts. 54, no? 55.
55.
55. But please take, my lord, the fourth line. The third line. Broadly speaking, judicial review in India comprises three aspects. Judicial review of legislative action that we are not concerned over here. Judicial review of judicial decisions, which Mr. Bhattacharya is submitting. And judicial review of administrative action. Therefore, if the division bench has been bestowed with the or restored the power of judicial review, because the Supreme Court, in my very humble submission, must have been aware that there are high courts like Calcutta High Court where writ petitions are moved in the single bench. The presumption is that they are aware. Then also, when the Supreme Court feels that the power of judicial review should be restored to the division bench of the High Court, possibly, in my very humble submission, the Supreme Court wanted to avoid a right of appeal in the judicial review of either judicial decisions or administrative action. Possible. Again, with the caveat, I say that L. Chandra Kumar was not considering this kind of a situation. Because nothing could have prevented the Supreme Court to restore the power of judicial review in single benches in most of the high courts. Therefore, the submission that if one is asked to come directly to the division bench, the division bench will not be facilitated in having the reasons of a judicial decision, may not be, in my very humble submission, a correct approach in the matter, because judicial review is also of an administrative action. Because they're all coming against, somebody will come against dismissal, somebody will come against suspension, somebody is not getting his pay, somebody is not getting his promotion.
So that is also permissible under the garb of judicial review.
Whether it is before the single judge or before the division bench, Miller, the same judicial review is available. Now the next argument is that I lose a right of appeal, or the state also, or the respondent also lose a right of appeal.
But a forum is lost.
Yes, that's what.
Scheme of the scheme which was framed basically, or the procedure which developed due to by virtue of the judgment in L. Chandrakumar, first tribunal, then before the division bench in judicial review, and then before the Supreme Court. Now, if I accept your contention that yes, as the definition of judicial review as subscribed, that it allows, or it is permissible to exercise power of judicial review over the decision of administrative authority, and that is permissible under the scheme of L. Chandrakumar directly by the division bench, then the one forum is lost in the midst.
Well, right of appeal is always a vested right. Right of appeal is created under a statute.
It's a substantial right.
Now, this right of appeal cannot be created or exercised in the absence of a statute. Take an example, Millard, section 100 was not there in the CPC. In that case, nobody could have preferred a second appeal. Take an example, clause 15 was not there in the latest patent. In that case, there could not have been a second or the intra-court appeal from the honorable single judge's order from a division to a division bench. Therefore, because of clause 15, we travel from the single judge to the division bench within the same court, in the same court. Today, please consider, Millard, after 323A(b) plus Administrative Tribunals Act or whatever, whether, Millard, clause 15 survives or not. Assuming for argument's sake, Millard, today, Millard, they can move the single bench. Clause 15 is not available. How can they approach the appeal court from a single judge's order?
No, as it has been argued by Mr. Bhattacharya in reference to the observations made in L. Chandrakumar, that just a minute, that while this paragraph 99, that while this jurisdiction cannot be ousted, other courts and tribunals may perform a supplemental role in discharging powers conferred by Article 226, 227, and 32 of the Constitution. Paragraph 19 at the middle. Paragraph 99 at the middle.
Yes, sir.
Please come to paragraph.
Yes, I'm here. Yes.
So the jurisdiction of the High Court cannot be ousted. Other courts and tribunals may perform a supplemental role in discharging the powers conferred by Article 226, 227, and 32 of the Constitution.
Right.
Now, when this tribunal is not there, whole system is restored.
The next sentence. The tribunals created under Article 323A(b) of the Constitution are possessed of the competence to test the assurance of validity. All decisions of these tribunals will, however, be subject to the scrutiny of a division bench of the High Court. Therefore, When the tribunal.
That is in connection with the power of the tribunal, whether the jurisdiction should be based out upon the tribunal to consider the fides of any act.
Right, right, any.
That is in that context, this observation was made.
Yes, but in that case, we'll kindly take before that, because this concept of the supplemental jurisdiction in paragraph 99 is
So
definitely.
therefore, it subject to hearing you, Mr. Dotto, it appears prima facie subject to hearing you that when the tribunal is there, then the scheme as framed on the basis of the or by virtue of the judgment of L. Chandra Kumar remains. If tribunal is not available, then the entire scheme breaks.
Well, I'll give you a different example. For the time being, keep aside Article 323A, B, L. Chandra Kumar, everything. What happens, my lord, when your lordships go on vacation? Not, I'm not talking about High Court. I'm talking about the subordinate courts. And I have an urgent suit to file. High courts have vacation bench. Lower courts, I'm talking about the civil courts, do not have. What happens if I need to file a suit? Because the entire court is closed. What is the remedy available? The remedy is to come before the High Court under 227 without filing a suit. This is very important. But I have successfully argued a matter where, my lord, during the vacation in the High Court, my lord, I had before Justice Sanjeev Banerjee, his lordship did a lot of research, my lord, and came back and said that no, you are right. He entertained, my lord, the Article 227 without a suit. Therefore, in the context of, because Supreme Court everywhere writes 226/227.
Right.
The two parameters cannot be invented, one for 226, the other for 227. Because if a 227 can be entertained without filing a suit, and an injunction can be passed or refused, whatever. It can also be done here under 226 laws. Because judicial review by a division bench against an administrative action is available.
Taking cue from the observations or the definitions as contained in paragraph 55.
Or in other words, my respectful submission is that you do not always require a judicial exercise before a judicial review. Because the tribunal exercises judicial functions. I'm trying to put forth before your lordship all possible avenues which need to be what should I say, taken note of. That is the 227 is a better example to please, because instead of moving this code, take an example. Somebody wanted to move a 227. Generally, we do not. The power is there.
Power of superintendence.
Power of superintendence. There were two impediments over there. Number one is from a 227, as per latest patent, there is no intra-court appeal.
But whether a litigant, right of a litigant to approach or to exercise or to get the benefit of provisions under Article 226 can be shut in such a manner when the tribunal is not functioning. No, you don't approach the High Court under 226, rather you approach under 227. Whether that can be restricted.
Power or the right is not being restricted. In this case, your lordships are permitting, because of exceptional situation, permitting the litigants to skip one forum. Power of judicial review is there. ordinarily or as per the scheme of the things, you must go first before the tribunal, get an adjudication, then come before the division bench. No dispute on that. But the right, that's why I started by saying access to justice cannot be denied. Now, is this access qualified by single bench and division bench? So that is Miller the law. Law will tell you whether you have to go to the lower court, higher court, Supreme Court, single bench, division bench, etc. But today, Miller, the law has been framed in such a manner that one has to go before the tribunal, if not where? If not, Miller, if the single benches are approached, then Miller, a forum will be created contrary to Miller L. Chandra Kumar and our latest patent. That would be my third submission. What is troubling the court is, are the litigants not being denied access to justice? Miller, approaching the division bench, Miller, in my humble understanding, will not deny, rather enforce the right to access justice, though L. Chandra Kumar was on a different angle. L. Chandra Kumar said that how can the High Court's power be taken away?
Yes.
But this would, Miller, approaching the division bench, Miller, in my humble understanding, will in no way affect, but rather enforce the right to or right of access to justice, which your lordships have held is a part of Article 21, one of the facets of Article 21. Moving a single bench or moving a division bench is not part of Article 21. Judicial.
What is required to be ensured is that access to justice is ensured.
Right. Now consider another angle. We have our latest patent. This was by way of a charter. This was, I believe it was before the first Government of India Act. I am not very sure about it. But Miller, when we got our constitution, the Government of India Act 1930 or 35.
1935.
Government of India Act 35 was there, which had a similar provision to that of Article 225 of our Constitution. It was possibly 107 in the Government of India Act, which says that, if you may kindly have a look to Miller, the Article 225. Jurisdiction of existing high courts.
Yes.
Subject to the provisions of this Constitution and to the provisions of any law of the appropriate legislature, made by virtue of powers conferred on that legislature. By this Constitution, the jurisdiction of and the law administered in any existing high courts and the respective powers of the judge thereof in relation to the administration of justice in the court, including any power to make rules of court and to regulate the sittings of the court and of the members thereof, sitting alone or in division courts, shall be the same as immediately before the commencement of this Constitution. So whatever was there before the Constitution will prevail, subject to
Provided.
the provisions of this Constitution and to the provisions of law made by such and such. Now this subject to is 323A and B. Otherwise, what was there had continued till we got this, I think it was which amendment, 44th or whatever.
42nd amendment. It is
I think it's the 75th. No. Yes, 42nd, not 44. 42nd.
42nd amendment.
First.
Paragraph 5 it is stated.
Yes.
L. Chandra Kumar,
L.
47. 1976. Yes.
With this, we are kindly have a look at Article 374. 72, sorry.
$372.
Yes. Why 372? Your latest patent is continued.
Yes, 372.
Notwithstanding the repeal of this constitution of the enactments referred to in Article 395 and subject to the provisions of this constitution, all the laws in force in the territory of India immediately before the commencement of this constitution shall continue in force therein until altered or repealed or amended by a competent legislature or other competent authority for the purpose of bringing the provisions of any law in force in the territory into accord within the provisions of this constitution. We are not concerned about two. Therefore, the right to go before a division bench,
yes,
can be claimed only by virtue of clause 15. Now, clause 15 is not here. How? Because, my lord, of this alternate institutional mechanism and latest patent itself says under clause 44 that the powers under latest patent can be curtailed only by an appropriate law of the competent legislature. So therefore, the moment the Administrative Tribunals Act was enacted, where clause 15 ceased to exist.
yes.
Therefore, Milord, please consider, but I am highlighting that all the points that came to my mind for your Lordship's consideration. Therefore, by simply saying that I lose a forum, Milord, may not be, Milord, an answer to entertain or allowing,
Writ petition.
no, allowing someone to move the single judge.
Single bench by this court. So far,
Yes.
this bench is concerned to entertain a writ petition.
Because there are two basic facets. Judicial review or 226, 227 restored to division bench. And number two is to travel from single bench to division bench, the law is not prevailing today. Because
So that option or that right is not available, right to prefer an appeal.
Because the avenue through which I come to a division bench from a single bench is not available to me today.
And it's a substantial right, to prefer an appeal.
Big right. That is why 323A to D empowers legislature to legislate inter alia to exclude the jurisdiction of the courts, and jurisdiction of the courts have, including the High Court in its entirety, has been taken away by Section 28 of the Administrative Tribunals Act, and Supreme Court had restored it only to the division bench.
And you are also relying upon clause 44 of latest patent.
Well, I've forgotten to bring it. Latest patent.
Due to constitution of a of tribunal under 1985 Act vis-a-vis 323A, by virtue of clause 44 of LPA, right to prefer appeal does not remain. That is your submission. In that event, according to, if this writ petition is entertained by the single bench, in that there is that litigant will lose a forum.
Yes. Or at least, then in that case, where I would venture to argue that your lordship has to accept Mr. Bhattacharya's submission. Then your lordship has to rewrite Supreme Court judgment. In that case, it becomes single bench, division bench 136, or single bench, direct 136. Neither of
But
these-
there is another aspect which is troubling Mr. Dotto, though these points were not considered, that there are two orders passed by the Honorable Division Bench. In one order, one of my order, in one order of the Honorable Division Bench, one of my orders has been set aside. And in another division bench has also decided that no, it is maintained. So that is binding upon me. At the best, I can refer the matter before the division bench for further consideration.
That your lordship can. Rather than your lordship, I forget that judgment where Milord, a single judge had differed with the division bench and referred it to the larger bench, where I placed a passage from someone on jurisdiction, on jurisprudence. This is a situation where your lordship may differ with it. We should differ with it, or say that these points were not urged and not.
Sir, Doctor, please find out. There's a judgment I come across delivered by order passed by Justice Doctor. It was an issue of 10 years requirement to obtain pension by a teacher. Then division bench made a finding and a final order was passed. On a identical issue, matter was decided. Matter came before Justice Doctor, and Justice Doctor was not in agreement with the view expressed by the division bench, and the matter was referred before the division bench.
But I know of a judgment.
DCRB, that is in connection with the DCRB scheme, a particular clause of DCRB scheme requiring 10 years minimum service for making a teacher eligible to get pension.
Look, your lordship can do another thing. So it's only a suggestion. Our rules provide that in a case where important questions, appellate side motion, important questions are involved, where the single judge can entertain a writ petition and make it returnable before a division, or request the chief justice to make it returnable, but not before a larger.
Yes, that single bench cannot. If I differ with the view of another single bench, then I can refer the matter before refer the matter before the chief justice for constitution of a bench. But when there are two decisions of the division bench on this aspect, that is also a issue that needs.
My humble submission would be that for your lordship's consideration, none of these are state decisions. State decisions will not apply because these points subject to correction were not considered. Maybe I am absolutely wrong in my understanding. But these needs to be considered. But I think if the law is settled, let it be settled. But the best option is to file a petition over there and come before the division bench under 226 or 227. That would be, I think, the best way.
No, if I am required to take such a view, considering the respective submissions of the parties. In that event, I need to defer the view expressed by the division bench, because one of my orders has been set aside by the division bench.
Yes, I agree with that. There would be a sort of judicial obstinacy also.
Yes.
But if points,
Points which are raising, yes, these points are not considered, especially based on clause 44 of LPA, whether after constitution of tribunal in terms of 1985 Act, whether latest patent appeal provision survives or not.
my understanding is clause 15 is not surviving anymore.
So there are two orders.
Yes, one is that Arnav something, Arnav Adhikari.
This is the have you, yes, Arnav Adhikari.
Yes.
That is wherein this issue was considered, and my order was set aside.
But Arnavের single bench টা আছে?
Yes, this is a single bench order.
Because I don't, আছে?
Yes.
না, division bench না। May please have a look to paragraph 4 of my lord's order.
Yes.
In Arnav. If administrative tribunal is not in a position to hear the matter since bench is not available, petitioner shall be at, it should be liberty to take steps in accordance with law. That's all. The lordship has not decided anything. It's more in the nature of a Millard an advisory jurisdiction. There's nothing decided. And the division bench.
And division bench has said,
Division bench.
paragraph 6.
Paragraph 6, will you please take the last sentence. If tribunal was not functioning, it was obligatory on the part of this court to hear the matter, otherwise the party will be remedies. But Millard, again, Millard, what is not urged, what is not decided, but those cannot be incorporated in this. But after all my submissions, your lordship may come to a decision against me, saying that no, I have jurisdiction. That your lordship can reach to the same conclusion. But I would be very humbly submitting merely because in an earlier litigation, my lord's order has been set aside and the matter has been remanded. But that is, with respect to, there's no ratio decidendi in it. It's a mere direction, not a judgment. It's an order.
Same thing is echoed as it was decided in the case of in Rangarajan's case, that if tribunal was not functional, it was obligatory on the part of this court to hear the matter, otherwise the party will be remedieless.
But Rangarajan, I've got some confusion here. Because in the first part of Rangarajan, it was said that I think there was a mass termination of services. 1 or 2 persons had moved before the High Court. High Court said nothing doing. No, High Court entered it. I'm sorry.
High Court entered
it. Single bench entered it. Then it went before the division and then it went to
Kalburgi bench of Karnataka High Court dismissed, sent it to the tribunal, and the principal bench said otherwise. Then division bench says no, you need to approach the tribunal. But the issue was there that the 200 state government employees were terminated, and there was one member in the tribunal. On this backdrop of facts, in paragraph 25, it was decided no, the litigants cannot be rendered remediless.
But
Here the situation is acute. There is no member at all.
But please take me paragraph.
Mr. Dotto, please come on the next date, and if necessary, by with a note, short note.
The presence of Mr. Dotto, one line, may I just, since it is fresh in our minds, paragraph 55 has been shown by us. One
Yes.
line, my lord, last line.
Paragraph 55 of Chandra
El
Kumar.
Chandra- El Chandra-
Just a minute.
Yes.
Just a minute.
293.
Yes.
Broadly speaking, judicial review in Indian conference such and such. Judicial review, last line. We are for the present concerned with only the understanding the first and
First
Well,
two aspects.
first two aspects. So therefore, legislative action, judicial review, and judicial review of judicial decision. And this has to be read along with paragraph 99, where all decisions have been said.
No
This
dispute
is a
on it.
judicial decision.
So you are submitting that the judicial review of administrative action was not considered.
No. And in El Chandra Kumar, paragraph 99, it has been said that decisions have to be there. So that decision has to be read as a judicial decision.
But my submission is that 226, 227 bench or a division bench can also judicially review administrative action. El Chandra Kumar does not say that this division bench cannot undertake judicial review of administrative action. That doesn't say.
It has been said decisions. So therefore, decisions is judicial decision. Since El Chandra Kumar was considering,
So let me ponder over it.
yes, yes.
And Mr. Dotto has
We'll
taken a
also come
very
back on this
very
point.
interesting point. I didn't think of it, that if Mr. Lahiri also think over it.
Yes, yes.
That
this
if
Letters patent.
let us put it.
Yes, yes.
Now you are taking the point from the side of the petitioner from very beginning. This is being urged that we will lose a forum
Forum, yes.
if we are sent to the division bench.
Treat as
Now,
judicial
if that is the division bench, if this at the first instance the writ petition is entertained by the single bench, in that event the option or the provision of appeal based on in terms of clause 15 of letters patent is not available.
Will not. I'll consider this.
Is
This
not
has to
available.
proceed, yes.
So the only window which is left is to straightway approach the Supreme Court under Article 136.
And that would be contrary to El Chandra Kumar, as submitted by learned advocate general.
No, as I've said, El Chandra Kumar was not.
But I am still I am saying that I am confronted with two decisions of the division bench.
This argument, as I have
Otherwise, I would not have hesitated to accept the contention of the advocate general. That is because that issue has not been gone into.
Right.
That issue has not been gone into.
Roger Matthews here again.
Because
comes.
at the first instance, that was my very first impression
That is the
that
beginning.
the issue needs to be heard by the division bench. But subsequently, the decision which has been cited by Mr. Bhattacharya, especially Rangarajan's case, and thereafter Roger Matthews' case, paragraph 392, that supports the case of the petitioner. But nowhere it is submitted. It is clarified. It is made clear that whether it is to be before the first forum of the High Court or the division bench of High Court.
In Roger Matthew itself, this three-tier judicial system has been taken into account, and in paragraph 394, three-tier has been also explained. So Roger Matthew will also be relevant.
Yes, I'll place.
There is one uncharted area, Mr. Dov.
Yes, sir.
So for the division bench vis-a-vis single bench,
Hmm.
nowhere it is made clear.
That is why we are before your lordship.
Well, on Tuesday, because the matter has to be decided, because litigants
Matters
are,
Tuesday, many matters are returnable before lordship.
and this court,
Na,
every day matters are coming, and this court, I am
Filing.
telling you, will be transformed into a tribunal.
No, as it used to be prior to the formation.
But that cannot be a consideration in deciding the issue. That cannot be a consideration in deciding the issue. But I apprehend.
Right now, what comes to my mind, I need to check it up also. Look into our classification list. Will this fit into the classification list under the RIT rules? That has also to be looked into.
No, this.
Because the classification list is meant for only the single benches. Initially. Then it goes before the obviously division bench. I look into that also. I look into that. 665. No, আমি তো classification আলাদা করে দিয়েছি না এই 226 227.
Administrative job.
এগুলো administrative, definitely.
That has to be considered based on the RIT rules and the classification list of different types of RIT proceedings. So what is you are trying to
a matter under Article 323 A and B. Today it is a matter which falls. It just came to my mind. I have not thought of over there. Tribunal decides service matters under section 3Q possibly.
Yes.
Today your lordship is asked to decide 3Q. Matters falling under 3Q. Or in other words, lack of jurisdiction or lack of availability of the tribunal due to lack of availability of the tribunal.
But these are the rules, Mr. Dotto. It's a handful of procedure, nothing
No
else.
doubt about it. But these are all under 225.
If required, then it is to be amended.
Yes, definitely. But
that will not hinder this court to take a decision.
We cannot ignore these rules are all under Article 225 of the Constitution. If I move a Group 7 matter before a Group 6 judge,
Sir,
quorum non juris. Therefore, these are enforceable as statutes. Definitely for administrative purpose. I don't deny that.
The procedural aspect. If ultimately the decision is taken, then
what of
the necessary amendment has to be carried out.
What of substantive value?
Well, on Tuesday at 2 p.m. It has to be hard because every day litigants are approaching this court and I'm deferring the matters since the issue, the preliminary issue is pending. Issue.
Tuesday 2 p.m.
Matter is heard at length. Mr. Vikas Ranjan Bhattacharya, learned senior advocate, has learned senior advocate appearing for the petitioner has concluded submission. Mr. Kishore Dotto, learned advocate general, has made submissions. Hearing is adjourned. List the matter under the same heading as 2 p.m. fixed matter on Tuesday next 13th January 2026.
Lordship, in this matter, I am appearing on Lordship behalf of the Lordship. State Lordship, Advocate General is Lordship.
I'm referring.
Judgment
for the list.
Item number 6.
My lord, I am for petitioner, Mr. Ajit Kumar Majumdar. Reading this matter, he is injured. Kindly not this week, my lord.
As your lordship, but there is no scope of interim order because
No, not this week, let him come. Not this week.
Item number 7.
Here your lordship for an interim order.
Now, petitioner was permitted to participate in the medical examination.
Test has been conducted. Also dispose of this matter.
Where is the, I have passed an order relying upon the
Yes,
judgment.
that Rohan Kumar Ghosh case.
the report is awarded, my lord. Report I have not received. Report.
No, I have already decided the issue of 169.5 centimeter by delivering a judgment. On a batch of matters, group of matters. It is a case 169.5.
169.5 and above. This case was 169.5.
Thank you. এটাতে কত আছে? এটাতে কত আছে? হ্যাঁ? 32.
এই শোনো, একটা লাইন এখানে প্যারাগ্রাফ অ্যাড করবে, 5-এর পরে 6 একটা প্যারাগ্রাফ অ্যাড করে দেবে। It is submitted by the learned advocate representing the petitioner that pursuant to the order passed by this court on 15 December 2025, petitioner was permitted to participate in medical examination. তারপর তাহলে এটা যদি 6 হয় তাহলে এটা 7, 8, 9. No appeal preferred.
Your lordship's order, this order appeal, no appeal as well.
I have decided this. আচ্ছা, এটাই কাউন্টার সাইন করে রেখে দেবে যেরকম ডিসপোজ অফ। Next.
Item number 8.
8, my lord, similar. My lord, here 169.8. Height is 169.
Page.
Page 30.
Same order, height is 169.8 লিখে রাখো, এই একটাই চেঞ্জ হবে। আর এইটা থেকে do you have a copy of this judgment?
Another copy I have given to my lord.
Let this copy be with him. ওটা থেকেই জেরক্স করে নেবে, আগেরটা থেকে করে নিয়ে রেখে দেবে। প্রত্যেকটাতে ওর কাউন্টার সিগনেচার করা একটা করে কপি ঢুকে দেবে। Yes, disposed of.
Item number 9.
9, may I please your lordship, here also same.
Height.
169.7, page 33.
Interim order was passed permitting you to participate in the medical test.
Yes.
Such test was conducted, my lord.
Height 169.7 centimeter. Height 169.7 centimeter. Same order, প্যারাগ্রাফ 60 অ্যাড হয়ে যাবে। কপি প্রত্যেকটা একটা করে নেবে, নিয়ে প্রত্যেকটাতে কাউন্টার সাইড করে রেখে দেবে।
12টা। Item number 10.
I for the petitioner mother, I have served Union of India, but the advocate on records father has died, so he will not be able to appear. So I will not be able to.
Only thing, my lord, I am appearing for Union of India. I do not know who is appearing for respondent number
I
2.
have thought, but to show that the affidavit service.
You are not the advocate.
I'm not the advocate record. I will do the matter, madam.
Who is Devopriya Mojumdar?
I am the Mojumdar.
Advocate on record, father died.
I can continue the matter, madam. That is not difficult.
No, it's up to you. Whether you are praying for time or not, it's up to you.
But I am not the answering respondent, my lord.
I have to file the affidavit service.
Issue at the time of call, accommodation is paid for on behalf of the petitioner. Since the learned advocate, since advocate on record for the petitioner, has paid for accommodation, কি বললাম? At the time of call, accommodation is paid for on behalf of the petitioner on the personal ground of the advocate on record for the petitioner. Next paragraph, Union of India is represented by learned. You are representing Union of India?
Yes, my lord.
Union of India is represented by learned advocate. Next paragraph, hearing of this matter stands adjourned. Stop. Next paragraph, list the matter under the same heading for further consideration on 27th January 2026. Next.
Item number 11.
11, may I please your lordship, I am for the petitioner, here also height. My lord, your lordship, as per your lordship's order.
Interim order was passed permitting the petitioner to participate in the medical test.
My lord, 169.
169.6 centimeter height. Same order, paragraph 6 is to be inserted and the judgment, copy of the judgment to be retained with the record, sound countersigned, assistant registrar court.
My lord, in this matter,
Item number 12.
I should have to.
Yes,
mention,
yes.
My lord, the petitioner has not been informed that he has allowed to participate. My learned friend, if that confirm
You
that.
have to allow to participate in the medical test.
Medical.
Yes, medical test has been conducted. That is,
But this petitioner only, he did not intimated that he has.
আচ্ছা তাহলে একটা
It has
কাজ
been
করো, ওই
conducted.
প্যারাগ্রাফটা কি বললাম একটু এদিকে
দেখো,
You have instruction that petitioner was permitted to participate in
yes, yes,
medical test.
medical examination has been conducted.
আচ্ছা ওই
কি নাম
কি
কি
বলেছিলাম
নাম?
বলতে পারবে?
সোহেল আহমেদ।
সুসেল আহমেদ
হ্যাঁ,
সোহেল।
সুশীল।
এই তো আছে, করেছে।
ওই এই ডেটটাও কিন্তু চেঞ্জ হতে থাকবে। মানে লাস্ট অর্ডারটা দেখে যে অর্ডারটা হয়েছে সেই অর্ডারটা দেখে দেখি ফাইলটা দাও। Pursuant to the order dated 15, হ্যাঁ একই ডেট 15 December 2025. আবার সেন্টেন্সটা বড় মিস করে গেলাম। Now, it is submitted by the learned advocate representing the Union of India. Representing the Union of India that petitioner was permitted to participate in medical test pursuant to the order dated 15 December 2025. Done. Same order.
Gate. পরেরটা 169.9.
এটাতে শুধু চেঞ্জ হয়ে গেল। হ্যাঁ, কারণ ওর কাছে ইনস্ট্রাকশন। This is item number 11.
11.
That is the item number.
Disposed of.
Item number 12.
May I please, Lordship, I am for the petitioner. Here also the height issue 169.9. Your Lordship, as per your Lordship's order, he has participated in the medical examination.
Order dated 15 December 2025, 169.9 centimeter, disposed of. প্রত্যেক কটাতে ওই জাজমেন্টের কপিটা জেরক্স লাগবে।
Item number 13.
13, may I please, your Lordship, here also the height issue, my lord, here 169.6. In my supplementary affidavit, I have page 4. Page 4 of my.
These matters are coming in terms of my previous direction. I meant to come on 8 January 2020.
Yes. Some matter your Lordship speaks 8.
You have instruction that petitioner was permitted.
This petition.
169.6 centimeter. Paragraph 6 is to be inserted. Order dated 15 December 2025.
They have provided a copy of the instruction, my lord, where it is stated that they are allowed to participate.
Petitioner is also submitting that.
Item number 14.
14, may I please, your Lordship, I am for the petitioner. Here also height.
কোনটা নাম কি?
এটা হচ্ছে 169.7, page 33.
169.7 centimeter.
7 centimeter.
169.7 centimeter, order dated 15 December 2025, same order. Disposed of.
পেজ কত ছিল আগেরটা?
Item number 15.
Here also, my lord, the height issue. Here height is 169.7, page 31. Page 31 of.
Height is 169.7 centimeter, order dated 15 December 2025. Disposed of.
Item number 16.
16, may I please, Lordship, I am for the here also height issue, my lord, 169.8.
You are appearing in this matter.
Page 31.
Page 31.
Yes, sir.
169.8 centimeter, order dated 15 December 2025, disposed of.
Item number 17.
May I please, Lordship, I am for the petition. My lord, here height is 169.6 centimeter. Page 30.
169.6 centimeter,
Page 36.
15 December 2025. Same order. Disposed of.
Item number 18.
Here also height is 169.5, page 32.
Yes.
169.5 centimeter, order dated 15 December 2025 disposed of.
Item number 19.
May I please, Your Lordship, I am Padaviji. Here also height issue, my lord, 169.6, page 31.
169.6 centimeter, order dated 15 December 2025, disposed of.
Item number 20.
20, may I please, Your Lordship. Here also height issue, my lord, 169.9 centimeter. Page 30.
169.9 centimeter, order dated 15 December 2025, disposed of.
Achha.
Item number 21.
Number 21. Lordship, this matter relates to recovery of the alleged overpayment from my leave salary.
Other side.
Other side, Mr. Bihani is appearing for CFTC. Lordship, one more thing, Lordship, in my.
Not today, inform the other side, not.
On the 16th of December 2025, this amount is different. It should be 93,486 instead of 4,26,063. My lord's order 18/12/2020. Yes, Mr. Bush has come, Your Lordship.
Yes.
My lord, the petitioner retired from service on 30th of November 2023 from Calcutta State Transport Corporation.
Just a minute. So deduction was 9499.
93,486.
Now come to page 12.
My petition. Page 12.
Yes.
Page 12, Your Lordship. This
Deduct
is the pay slip.
9499.
No, Your Lordship. The page number 12, this is the pay slip, Your Lordship.
Yes.
So, Your Lordship, pay slip, the earn leave is 62 days earn leave. So, it amounts to 62 days earn leave comes to 93,400.
No, but there is a incorporation that deduction to the extent of rupees 9499.
No, your deduction.
Yes, at the bottom.
Lordship,
At the bottom.
yes, deduction is 9499 payable 55932. It includes some other also, Your Lordship. But if my lord will calculate the earned leave, means
No, it was not calculation. It's a mere recording of fact. It is submitted on behalf of the petitioner. Rupees 726,063 was the total amount. Provisional leave balance.
Lordship.
Provisional leave balance. 7,26,63. What is that? Page 12.
Page.
Dilip Kumar Manna, WPA 28232.
Yes, Your Lordship. Dilip Kumar Manna.
Yes. Provisional leave balance at the bottom right hand side.
Provisional leave balance 1/11/2023 is
72.
62.762. Minor earned leave 62.72603. Kindly let it be done, Your Lordship. The earned leave is 62 days. The other 0.72 is nothing, Your Lordship. So earned leave is 62 days. And if my lord will calculate.
And it is deduct 9499.
Lordship, it was, but the earned leave, if my lord will count 32 days, 62 days earned leave, if that will be counted, it will come to 93.
That is different thing.
Lordship, may I place one thing, Your Lordship?
Only correction is necessary, that is instead of 726
Lordship,
063, it will be 9499.
No. Lordship, they will count it 62 days leave. They have deducted the amount from 62 days leave. Let them count their 62 days leave and refund it to me with interest. That is my whole prayer. Let it be calculated by the
No,
responsible.
but they decided to deduct 9499.
But that counts to other thing also. PF loan, that amount comes to 9499, payable 55932. I mean, other heads are also there. So my prayer before your lordship, the recovery is for 62 days earned leave. So they will calculate how much it comes and they will give it to me, refund it to me. That is my whole prayer. I'm not on any calculation or anything. Let them calculate my 62 days earned leave. They have deducted it from my leave salary, the amount. So I'm not going to that amount.
But what is 62.726063?
Lordship, 62 days leave. What my
It doesn't make any sense. If it is 62 days leave, then why it is stated 62.726063?
Lordship, that's the other day Mr. Bihani has asked for the time to take that instruction. What is that 62.72? My instruction is that earned leave comes to 62 days. So I'm entitled to get that amount, 62 days leave. Because I've already received an amount of 31,000 and odd towards my leave salary. But if my lord will...
No, this is pay slip of November 2020. There was a deduction to the extent of 9499.
Lordship, that's what Mr. Bihani used to have to take the instruction. What does this stand? The other occasion, Mr. Bihani is asked for time for that.
No, see my order, paragraph 2.
Lordship,
Question: deductions made by the concerned authority of Calcutta State Corporation as it is reflected from the pay slip of November 2020.
Lordship, they will
So my order was restricted to pay slip.
Absolutely, absolutely.
So it was decided to deduct 9499.
But my earned leave does not come to 959.
That will be decided later on. That will be decided later on, hearing both sides. But so far the previous order correction is concerned, which is required as you indicated, you are indicating, it will be 9499.
Just submitted the petition that was deducted from the leave salary. But my instruction is that 30.6.
That is different thing.
Lordship.
এই শো আগে কালেকশনটা করে দিই, তারপর ওদের কি ইনস্ট্রাকশন আছে শুনুন। Order dated 16 December 2025 requires correction. Second line of third paragraph of the order dated 16 December 2025. The amount to be read as 9499 instead of 726063. 726063. 9499 instead of 726063. Department is directed to incorporate necessary correction. Mr. Bihani, court was confined to the last occasion and pay slip of November 2023.
Page 12.
There it was inadvertently recorded, that deduction was 726063, but it should be 9499 because it is there is a stipulation at the bottom of page 12 that deduct 9499.
Lordship.
So it was decided by the authority to deduct 9499.
I tell your lordship, my lord, this is my lord, it fell from your lordship also. So my lord,
no, what is your instruction?
My instruction to this aspect is nothing. There is no instruction because of the fact that the person looking after this, my lord, has been discharged after an operation from the ICU only 2 days back.
So you want to?
I tried to take, but my lord, I couldn't pursue him in these circumstances.
Very well. Today, then I will not correct this order. Let Mr. Bihani comes.
Let me come back on Monday.
With the instruction.
Monday.
With the instruction.
Kindly gives me 1 week
time. It is necessary accordingly. This previous order.
Yes, whatever is the position, I shall, my lord, apprise your lordship.
Simply not this week.
Monday.
On Tuesday, not Monday.
Tuesday. My lord, I'll come back with you. I'll try and come back with you. Not sorry, my lord, I couldn't. Yes. I'm deeply okay.
করোনা
ওই শান্তনু বাবু কেস মেকার
তখন আবার ফার্দার কারেকশনের দরকার পড়ে যাবে।
Item number 22,
22, may I please, Your Lordship, for the petition.
Yes.
Last
My lord,
occasion,
I
Your
appear for the
Lordship,
respondent being led by Sri Partho Ghosh.
looking
I'm
at
being
the-
led by Sri Partho Ghosh. I appear for the respondent.
Yes.
that here my candidature has been rejected on the ground.
Just a minute. Yes.
My lord, my instruction is that there's general grounds for rejection. There is a list. He is having left ventricular hypertrophy is a disease of heart complication, and he's having borderline uh, left ventricular hypertrophy, and this is covered under subclause 3 of section clause 6, the indication of valvular or other disease of heart. The general grounds for rejection.
Page 20 is the detailed medical examination. Is it?
Yes, where is the relevant provision in the revised guidelines?
That has not been assigned in the detailed medical examination.
My lord, general grounds for rejection 6.3.
6.3.
My lord.
It is there under 6.3.
6.3 here.
Indication of valvular or other disease of
Other
heart.
disease of the heart.
And
It is
it
not
the
a-
report says unfit due to borderline left ventricular hypertrophy.
Yes, my
Lord,
lord.
that is a
In
disease
that
of the
event, my
heart.
lord, what they have done, my lord, kindly come to brief review medical examination findings. There is a indication of the heart blood pressure rate and heartbeat rate. There are indication within the limit I have. My lord,
You may
page
see
That he could have obtained by taking medicines and something he could have controlled that at the time of.
may have normal blood pressure. That does not mean your heart is fully
My lord, I am
Yes,
grateful.
that cardiologist says also that I have no cardiological
that
problem.
is I have decided in one matter, that is the parameters are different. So far these
Parameters are not different, my lord.
two
Parameters
medical assessments are
here parameters are given 140 up and 19 is down. The lower BP is 90 and upper 140. Here indication is there. The medical
Which-
guideline.
which certificate you are relying on?
My lord, their rejection order I am relying, and the very next page, page 22, also I am relying. Gandhi Memorial Hospital. Here the doctor who is a cardiologist, he certified. And
file a report
their documents also shows that
File
I
a
am
report
within the ceiling limit.
based on medical guidelines.
My
Something has to be there on record.
Oblige, Your Lordship.
It is submitted by the learned advocate representing the petitioner, representing the Union of India, that petitioner was correctly declared unfit due to borderline left ventricular hypertrophy. Stop. In this regard, reliance is placed on clause 6 within bracket 3 of the revised guidelines. Stop. Next paragraph. Concerned respondent authority is directed to file a report disclosing as to why petitioner was declared medically unfit based on revised guidelines. Next, let such report be filed by 2 weeks from date.
May I get 3 weeks?
By 3 weeks from date, list the matter under the same heading for further consideration. on 29 January 2026 or 29 Corona 3rd February 2026. 3rd February.
সকালে ফোন করে বলছি যে এটা গৌহাটির ম্যাটার 2 সপ্তাহ লাগবে এবং কালকে পিটিশন পেয়েছে
ঠিক আছে
Item number 23.
23, may I please, Your Lordship, I am for the petitioner.
কালকে
Here, my lord,
আউটজোনে পোস্টেড
my candidature has been rejected on the ground of multiple portal cabins.
কালকেই পেয়েছে হেডকোয়ার্টার গৌহাটি
It's a matter of, my lord, principal answering respondent is at Guwahati. Yesterday we have received this brief.
Yes, the department also called me for regarding the matter, but I could not ascertain who is assigned. My lord, Mr. Ghosh is appearing on behalf of the respondent. I could not ascertain.
But this order was passed previously on 16 December. What you are doing for such a long time?
হেডকোয়ার্টারটা দিল্লি তো দিল্লি থেকে ওখানে কত
We have sent in Delhi, my lord, then my lord routed through, my lord, different, my lord.
What routed through?
My lord, we have sent to the Delhi. They said, my lord, the answering respondent is Guwahati.
Communication is
7 days time ago.
is traveling through all the cities of our country.
No, my lord.
Then
Then we thought that the answering respondent is, my lord, at, my lord, Delhi.
ওরা বলছে মেডিকেল
why?
জিজ্ঞেস করতে হবে
Around same date, previous order was passed in previous matter,
সাধারণ
and instruction is there.
Well, I will bring, give me some days time. I will bring instruction.
My lord, the medical was conducted by Coach Bihar. At Coach Bihar, it should maybe it is under the Guwahati, the head office.
Head officer Guwahati. And my lord, problem is, my lord, they have all copies here.
Through the
Well, they have all copies in ministry's office at Kolkata. This is the, my lord, more difficulties, my lord, for us.
আগে একটাই
নাম দিয়েছে
কথা বলে
নাম দিয়েছে
এটাই
নামটা কি আগেরটা
আরেকটা ওনার নামটা 22টা স্ক্রিপ্ট আছে এটা একটা স্থিতি তো 25টা তো আর পেয়েছে এছাড়া আজ কিছু হয়
পরেরটা কি
পরেরটা তো কিছু করার নেই হাইট আর কেরাটা থেকে সব
নাম দাও
এটা ধরুন এসে স্যারের নামটা এলিয়ান আমি দুটো অর্ডার আছে কোনটা অর্ডার আছে আছে এদেরকে বলেও দিয়েছি এরা আসে খালি হিলি করতে
তোমরা এখানে বলছো
আমার কাছ থেকে স্ক্যান করে স্ক্যান করে নিয়ে গেছে আমার কাছ থেকে দিনে দিনে
বিএসএফ আছে আর কি রাজা অনলাইন
Will obtain instruction. Issue. At the time of call, learned advocate representing Union of India has prayed for accommodation to obtain instruction and has prayed for extension of time to obtain instruction in terms of the previous order dated 16 December 2025. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 29th January 2026.
Much obliged, grateful to us.
Item number 24.
No, 25 years.
Thank you, Your Lordship. Hello, this is about the illegal suspension of the additional regional transport authority, my lord. Hello,
The additional
regional transport authority, ARTO, Alipurduar.
Petitioner is an employee of Transport Department.
Yes.
And appointed, is an employee of Transport Department, appointment through the Public Service Commission.
How it is maintainable?
My lord, the similar matter SAT, it is maintainable before the SAT, but the SAT.
I am considering a matter today. I have heard this matter for more than 1 hour. So you have to wait for some time.
My lord,
Item
my lord,
number
he has
5,
been
my lord.
suffering the suspension
Yes,
since more than 1 year.
Preliminary issue has to be decided. Try to appreciate the predicament of
Not going into the merits because the show cause notice per se is bad. My lord, the show cause notice
for
was issued.
deciding the validity of show cause notice. I have to first decide whether the writ petition is maintainable before me or not.
My lord, if the SAT is not in session, my lord, the
What can be done? That issue is being heard. Advocate General is appearing. This matter was item number 5. We have to wait for some time.
My lord, till that time the
Sorry,
suspension
issue.
is lifted. My lord, I am
My lord,
just
that
saying-
is the item number 5 of today's list.
Yes, yes.
I'm praying for some interim measure, my lord.
No,
My
no,
lord,
at
I
this
am
stage I
praying
cannot.
for judgment.
At this stage I cannot. I cannot.
Lord, more-
In none of the matters I have allowed, since the issue is pending.
Let the matter be pending, my lord. My lord, just only
You are an
one-
officer of this court. Don't make a submission which doesn't make any sense. Today, if I pass an order, then I have to entertain your writ petition. When in another matter issue is pending, whether the writ petition is maintainable before this court or before the division bench. Without understanding, you go on making submission.
He is suffering more than 1 year, my lord. Just
17 December it was filed. You have to wait for some time. So other litigants are also waiting. Service petitioner is a state government employee and who has straight away approached this court seeking straightway this court under Article 226 of the Constitution of India seeking necessary direction, seeking mandamus. Stop. Next paragraph. Question arises for consideration whether writ petition at this stage is maintainable before the single bench of High Court or not. Stop. The issue is pending in identical issue is pending in connection with other matters before this court. Stop. List the matter under the same heading for further consideration on 3rd February 2026.
Item number 25.
Well, this is the first time the joint petition has been rejected by your lordship. The petitioner now filed a single petition, separate petition. It is with regard to the height issue, rounding of 169.5 and above. Well, this order, your lordship passed. Well, earlier this matter has.
Where is the 169.8?
169.8.
Issue has already been decided by this.
Item number 24 na 25 এটা? my lord, yes. Yes, my lord. Only, my lord, I will only pray, my lord, that the similar matter is pending. Now I leave it to your
I
lordship.
have decided the matter.
Yes.
I have decided, I have delivered a judgment.
Yes, I know, my lord.
So therefore nothing remains. Let me
As a
pass
lord-
same order, you test my order.
Very well.
Give me the copy of the order.
Yes, sir. I have just now. I have.
Where is the judgment?
Judgment. My lord, judgment, 2 copy was there, my lord, I have given.
No, you have to
2 copy
file
your
the
lordship
judgment.
and
In all
my lord.
matters, it cannot be
My lord,
handled in
last-
such.
Judgment.
My lord, in this, the copy of, just now I have handed over in that matter, here, 1 copy is indicated. Judgment. After passing this order, your lordship, judgment, this order has been passed.
ওই পরে আনিয়ে নি একটা করিয়ে নিয়ে ওর মধ্যে ঢুকিয়ে দিও। এটা জিনিস তো। জিনিস তো এখন। It's a physical measurement test report.
Page 32, physically measurement test. The 169.8.
It is in appeal.
It is in.
What is the nomenclature? The detailed physical test or
Nomenclature is a physical measurement test, PST.
PST, physical.
PST.
Physical standard test.
Stands up.
PST,
Physical
physical
standard.
standard. Against which appeal is preferred.
Physical measurement test report.
Standard.
EMTR. EMT. Physical measurement test.
This is 169.8.
8.
You will submit a copy of the judgment in course of this day. শোনো, এখানে যা আছে একই অর্ডার হবে 169.8 সেন্টিমিটার, শুধু হাইটটা চেঞ্জ হবে, দেখে নাও। আর ওর যে জাজমেন্টটা উনি দেবেন, ওয়ান্স জাজমেন্ট ডেটেড 18 ডিসেম্বর 2025, ওটাই তুমি কাউন্টার সাইন করে এর মধ্যে দিয়ে তারপর আমাকে ইয়েস ডিসপোজড অফ।
One pair, may I make? But here in this order, your lordship has not time bound in. But 29th is the Rozgar Mela, and the respondent authority are in hurry to publish the.
Let them take steps. If it is not complied with, then take steps.
So it is my duty to.
Item number 26. Item number 22, we have to file report, but our instructions has been, my lord, taken with the record, my lord. So we have
ইনস্ট্রাকশনটা আমি তো টেকেন অন রেকর্ড করি।
item number 22, my lord.
ডাকো ডাকো ডাকো, পরে ওদের দিয়ে দেবে।
Item number 26. 26. Grievance of the petitioner was considered, my lord.
Redressed.
Yes, my lord. My lord, and this is the order, my lord. They have transferred.
They have?
Petitioner has transferred from
He has been already transferred.
This is the order, my lord.
দেখি দাও। issue. Learned advocate representing the petitioner submits. Grievance of the petitioner stands redressed as petitioner has been transferred. Video order dated 5th January 2026. Stop. Next paragraph. Transfer. Order dated 5th January 2026 is taken. Copy of the transfer order dated 5th January 2026 is taken on record. Next paragraph. Union of India is represented by learned advocate. Next paragraph. In view of efforts and submission made on behalf of the petitioner, no further order need be passed on this writ petition. Stop. Writ petition stands disposed of. Parties to act on the server copy. Deep. Oh, তিনটে বাজে আমার মুখ।
Item number 55 from monthly list.
And for the petitioner, my lord.
Mapping for the respondent state, Your Lordship. Your Lordship, on previous occasion, Lordship directed us to
Yes, report. Yes, which paragraph you have stated?
Your Lordship,
The reason for not engaging the petitioner.
Your Lordship, the kindly come first to the page 7, annexure A, page 7.
Page 7 will come later where you have made the
Yes, Your
statement
Lordship.
in the affidavit.
Your Lordship, kindly come to page paragraph 5.
Now, who is to grant approval?
Your Lordship, the final approving authority is NACH,
National
State
Health Mission.
NHM, sir, yes.
Yes.
And Your Lordship, the sanction.
Whether National Health Mission is party in this writ petition.
Respond number 1, my lord. National Rural Health Mission, my lord. Secretary.
Yes, Your Worship. One, the state of through the Secretary, Department of Health and Family Welfare, National Rural Health Mission.
Which respondent?
One.
No, one, my lord.
One.
Then you are representing the state.
Yes, Your Worship.
Why the approval is not being accorded? Because come to page 4 of your report.
Yes, Your Worship.
Yes, first paragraph after 3 lines, although the correct information was formally sent to the program officer National Health Mission, the state National Health Mission cell, Department of Health and Family Welfare, Government of West Bengal has not yet issued approval for engaging so and so, and therefore she has not been engaged.
The sanction trend, the dispute is the sanction trend was 6, but the approval the sanction strength was for 6%. The approval was given for the 5. Now the 6th person is the petitioner herein, who has not been given appointment as the approval has
because there was a confusion with regard to number of posts.
Post.
But come to page 3, bottom paragraph 5. The issue arose because the sanctioned number of ASHA posts of Jaipur subcenter was incorrectly recorded. This incorrect figure had to be corrected. And clarification cum rectification letter, video memo number so and so date 15 March 2024 was sent to the state national health to confirm the actual sanction post and seek approval for filling up the vacancy.
Yes.
Copy of the report submitted by subdivision. Now, where is this letter? 15 March 2024.
Your Lordship, kindly come to the clarification 15th, 19th.
That is important in order to ascertain the number of posts which can be filled up.
Your Lordship, the clarification is page 19. The date is not there, Your Lordship, but for that is the letter, Your Lordship. Page 19. ওইটা আছে page 24 এটা আছে page 24, Your Lordship. এটা হচ্ছে মেন।
Yes, you are relying upon page 19.
Page 19 and page
against
20.
Jaipur subcenter. Yes, against Jaipur subcenter. Read these bullet points.
Yes, Your Lordship. Already approved. Asha was sanction number mentioned in the pro forma is 6. And already approved was 5. That is the only dispute. That's why we have need to
read it then thereafter.
Hence, proposal for issuance of approval in favor of one candidate is not considered. Now, because it will exceed the sanction number, correct sanction number need to be clarified.
That clarification is?
We have sought on page
that
24.
clarification is 15 March 2024?
No, Your Lordship.
Paragraph 5, yes. The issue arose because sanction number of ASHA posts for Jaipur subcenter was incorrectly recorded. This incorrect figure had to be corrected. And a clarification cum rectification letter video memo number so and so 15 March 2024 was sent to State National Health Mission.
Yes.
So that letter has to be seen.
That letter is
whether it is clarified as 5 or 6.
That letter is annexed to page 24, Your Lordship. But the clarification is not yet.
That is the issue raised
by
Additional Mission Director, National Health Mission. And this is the 15 March 2024 is the clarification.
But
In
till then,
response thereto,
Your Lordship,
where is such clarification letter?
Yes, Your Lordship. I understand, Your Lordship. My instruction is ki after this letter, they have again given a formal letter to the authority stating that the writ petition is pending and the court is asking for the report. But still now, the no clarification has.
No, I want to see this that this 15 March 2024 letter.
15 March 2024 letter is there, Your Lordship.
Where?
Page 24.
Page
24. But reply to that has not yet reached me.
Page 24.
Yes, Your Lordship.
Read page 24.
The clarification letter enclosed herewith for your kind information and necessary action to give approval as Asha under Ishanpur SC, Jaipur SC and so to Kharagpur block. Huh? Korgram block. Using the clarification letter enclosed.
Where is that letter? Enclosed here.
Yes. I understand. Lordship, kindly give me a 1 day's time. I will bring back this letter, Your Lordship.
Why you have filed a report and you have not disclosed the
Lordship,
most important letter in order to find out that how many posts are sanctioned.
Kindly give-
5, 5, 6, 6. These are required to be ascertained.
Yes, Your Lordship. My instruction is this sanction strength.
Your instruction will not. do.
Yes, Your Lordship. I understand.
Somebody has been selected but not given appointment. So
Okay.
your mere instruction will not do. What does paper say? That has to be considered.
Your Lordship, kindly give me 1 day's time.
Yes,
I will.
Report in the form of affidavit affirmed on 9 December 2025. By the subdivisional officer Kandi, Murshidabad, is taken on record. Next paragraph. It is found from the said report that there was confusion with regard to number of posts for Asha Kurmi or for Asha, ASHA. Under Jaipur Subcenter. And to that extent, a clarification letter, VDA memo dated 15 March 2024 was sent to the concerned authority of National Health Mission.
My one submission.
disclosing number of sanction strength, number of sanction posts for disclosing number of sanction posts under the said subcenter. Stop. However, said memo dated 15 March 2024 is not enclosed to the report filed today. Next paragraph. Client concerns respondent authority is directed to produce this memo dated 15 March 2024 as referred to in paragraph 5 of the report on the next date. List the matter under the same on the next date. Stop. Hearing of this writ petition, list the matter under the same heading or hearing of this matter stands adjourned till 19th January 2026.
To clarify, to sort, Your Lordship, if at all we consider this, the page 24 letter, Your Lordship, in this, they are saying that is an enclosed. The program officer, they are giving to their higher authority by the Chief Medical Officer Health, Murshidabad. So they are sending a clarification letter. What they have not annexed the letter by which they are raising the dispute before the higher authority. So if we get hold of that letter as well, that will not clear the doubt of this honorable court. The doubt could be cleared by the respondent one only.
The letter which has been referred to.
Yes, Lordship, that will be
paragraph 5.
Lordship, the entirety of the letter is not there.
Disclosed that this incorrect figure had to be corrected.
Yes.
And a clarification cum rectification letter wide memo dated 15 March 24 was sent to the State National Health Mission.
Yes.
To confirm the actual sanction post.
Yes, Lordship. So if we get hold of the entire letter of 15/3/24, so that is the letter which the
here memo is also indicated CN/MSD.
Lordship, the entirety of that.
Produce that letter.
Yes, Lordship. Now, if a report could be called for from the respondent one, that would become that the doubt of the court.
No, you have to produce this letter.
No,
You
both,
are referring to the memo number and everything.
Yes, Your Lordship.
Produce the letter.
Yes, Your Lordship. Deeply obliged.
Item number 57.
I am for the petitioner, my lord. I have served, including the private respondent also.
এটা 55 হলো এইটা না
11 November 2025, my lordship directed to serve again all the respondents. I serve all the respondents, including the state. This is the affidavit of service, my lord.
Yes.
My lord, case is that
affidavit of service.
My lord, affidavit of service. First one was a service, my lord, which is second.
Where is your affidavit of service? Yes.
My lord, petitioner, my lord, belong to the scheduled type community and my land user category, my lord.
Yes.
Land user category. He donated the land for the construction of the hostel, my lord. My lord, the post of superintendent of the said boys and girls hostel, my lord. My lord, petitioner applied for the post, my lord, as per notification. Kindly come to the notification, my lord. Notification is the notification.
Page.
Yes, my lord. Yes, my lord. Page 38, my lord, and it's a P3, my lord. Bengali, my lord. First, my lord, পদের নাম superintendent, পদের সংখ্যা 2.
Yes, page 38. Which part you are relying upon?
First, one, আবেদনকারী বয়স 40 বছর এবং তার কম হতে হবে, তফসিল জাতি উপজাতি আবেদনকারী। আবেদনকারী অবশ্যই গ্র্যাজুয়েট হতে হবে, সাগরদিঘি ব্লকের বারালা গ্রাম পঞ্চায়েতের বাসিন্দা হতে হবে, পূর্ব অভিজ্ঞতা থাকলে অগ্রাধিকার দেওয়া হবে। On that basis of the notice, my lord,
For the post of superintendent, yes.
The petitioners applied for examination was held, my lord, written test and viva, my lord.
Yes.
But my lord, without publishing any result, my lord, they have appointed another 2%, my lord. My lord,
Another
2% who are not qualified for the said post, my lord. My lord, petitioner is the most eligible candidate for the said post, my lord. He wrote a letter, my lord. He wrote a letter, my lord. That was not considered.
How many poder সংখ্যা, how many posts were? Two posts. Now against these two posts, how many candidates participated?
Yes, my lord. They have not disclosed anything, my lord. I have wrote a letter.
No, I'm asking you, are you aware of how many candidates participated?
My lord, my understanding is that my 4 candidates are there. 4.
4 candidates participated. If you do not come within the zone of
No, my lord.
consideration, how you will be appointed?
Not my submission is to publish the result.
Yes.
Result of the examination. They have not published it.
What result, under which provision that in an interview result has to be published? A panel will be prepared, from the panel payment.
So much. That is the
appointment.
panel was not published. Panel was not prepared. Panel was not.
Where you have stated in the
yes,
resolution?
I have stated. Oh no, my lord, 12 candidates participated. Yes, ma'am. 12 candidates.
So out of 12 candidates, you are one of the candidates, and 2 posts are there.
Yes, ma'am.
So it is not possible to accommodate all the 12 candidates.
Only for publish the panel, my lord. I ascertain, my lord.
Under what provision?
I am the
That a
most
panel
eligible
is to be
candidate.
needs to be prepared. A result is to be prepared, published, and it is to be intimated to the all
Intimated, my lord.
all the participants separately.
My grievance is that only to publish the panel, my lord.
Under which provision?
Panel was
Selection process
not sent to me, my lord. Only published in their hostel.
Selection process contains such provision, then question of communicating result arises. Otherwise not.
My lord, page 12, my lord, I have stated, my lord, paragraph 12, my lord. Your petitioner most respectfully stated that without publish the result of written test and personal interview, without disclosing the I read out, my lord. You should direct them to submit a report. My lord. If I not, my lord, come in the zone of the consideration, I will not.
For all the selection process, there is no provision for publication of result.
Only 2% first candidate and my lord, my result.
Out of 12, if you do not come within the zone of consideration, you will not be appointed. But where is the provision for publication of result?
I am the most eligible candidate for the same.
Everybody thinks so.
No, my lord.
That he is the most eligible candidate. But in reality, picture is otherwise. That's why there is a provision for preparation of panel. If you are an impanel candidate, question would have been different.
Produce the panel.
Well, you take instruction. Instruction. You are representing the state. Which authority?
Block Development Officer. Sagar Dighi.
Appointing authority is Block Development Officer Sagar Dighi. Yes?
My lord.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Grievance of the next paragraph. Grievance of the petitioner is she why 2 petitioners?
No, my lord, one girls hostel, my lord, one boys, one for boys, one for girls, my lord. 2 hostel are there, my lord.
No, but the post is 2.
2. One for girls, one for boys, my lord. One for
one post of superintendent for girls hostel and another for boys hostel. And these total 12 candidates, out of which two candidates have come forward.
2 hostel.
কি বলছিলাম? Petitioners is common grievance করো common grievance of the petitioners is what about court fee?
I undertake my lord to pay them in course of the day, my lord.
No. Come back. Leave is granted to the learned advocate representing the petitioner to deposit deficit court fees by 7 days from date. Stop. List the matter under the same heading for further consideration on 27 January 2026. In the meantime, you take obtain instruction. Come. Deposit court fees.
Item number 60.
For the response.
Or শোনো এটা কম্বাইন্ড লিস্ট থেকে তো হিয়ারিং অফ দিস ম্যাটার স্ট্যান্ডস অ্যাডজার্ন টিল ওই ডেট অবধি করে দেবে, বুঝতে পেরেছো? সাপ্লিমেন্টারি লিস্টে যাবে না এখন।
The matter relating to correction of date of birth. I am an employee of the
অথবা একটা শোনো, Mr. Mondol, let it appear in the monthly combined list of February. In the meantime, you deposit court fees. Yes.
This is a matter relating to correction of date of birth. I am an employee of the Eastern Coalfields Limited. If your lordship kindly come to the page 25.
You have retired?
No, I'm
when you will
retire?
retire?
I'm still in service.
When you will retire?
This year, June.
When you are appointed?
1995.
So what you are doing for such a long time at the
I
back
have-
end of your service career?
I have raised
Correction of date of birth?
I have raised dispute. It has not been considered. I have raised dispute just after my appointment.
There is a judgment of the Supreme Court that at the fag end of the service career, application for correction of date of birth ought not to be entertained.
I will also refer to some Supreme Court judgments which have in which case date of birth correction was allowed at the fag end, because I have raised the dispute just after my appointment.
Please place your case.
Page 25.
Yes.
It is the attestation forms which has to be submitted before the appointment. Now, if your lordship kindly turns over to page 26, column 7, if your lordship finds date of birth is mentioned as 25th day of January 1969. This is the actual date of birth. And now, column 10, the name of the school is also mentioned. Yes, and if your lordship now kindly turns over to page 27 and 28, this has been attested by the headmaster of the school. And if your lordship kindly sees the date 93, October 93 is the on which this attestation form was attested.
Where?
At the bottom, page 28 at the bottom, by the headmaster of the school.
It's not readable.
That is the best copy I have,
It's an identity certificate, madam. It's an identity certificate.
Yes, madam.
Just only an attestation.
Yes.
The date is mentioned as 93. 93 this has been attested. And page 29 if your lordship kindly comes. This is the certificate, and here also the date of birth is mentioned as 25th day of January 1969. Now if your lordship now comes to the appointment letter, that is page 23.
Yes.
Now this has been issued on 13/4/1995, and here if your lordship kindly sees, the date of birth is mentioned. Date of birth is assessed as 8 years as on 17/6/94.
Where?
Yes, just after the date at the very first. Date of birth is assessed as 28 years as on 17/6/1994. Assessed by the medical officers of the Satgram area hospital on 17/6/1994. This has been assessed.
Yes.
And now kindly comes to the page 30. This is the relevant portion of the implementation instruction which they has to follow. And this is page 30. Because if it is not particularly visible, I have a better purpose. And this is the full implementation instruction. And the one I have annexed at page 30 is the relevant portion only. And the relevant portion is 2. Here, it is annexure 1. Page 691. Page number is mentioned at the bottom of the page. Page 691.
Page
691, and the page is mentioned at the bottom of the page.
Yes.
Yes,
Ex-serviceman.
Yes, Manoj. It will be the Roman 2. Non-matriculars but educated. In case of appointees who have pursued studies in a recognized educational institution, the date of birth recorded in the school leaving certificate shall be treated as correct date of birth, and the same will not be altered under any circumstances. So, Manoj, at the time of appointment, I have submitted my school leaving certificate mentioning my correct date of birth, which has not been considered. Now, Manoj, just after that, I have raised this. Kindly comes.
Where is your school leaving certificate?
Yes, Manoj. Page 29.
Page 29.
Yes. The date of birth is mentioned at the middle. His date of birth is recorded as in admission register was 25th day of January 1916.
Yes.
So, Malas, along with these attestation forms, this has been submitted before the authority. Now, Malas, just after that, page 31, I have raised dispute. Page 31.
On what basis you recorded date of birth? You did not consider this school leaving certificate?
I will satisfy your lordship if your lordship asks me now, right now I will reply, my lord. But,
Yes.
Yes, but as a whole, this is to be replied, my lord. It's not the case what he is saying, that first of all, he is to prove that he has submitted the school leaving certificate, because unless and until
His school leaving certificate was not submitted.
not at that time, not at all, because if your lordship goes through this implementation instruction number 76, implementation instruction number 76.
Yes.
Yes. Whether he shows non-matriculates but
educated.
But educated. Now, in the case of appointees who have pursued studies in a recognized educational institution, The date of birth recorded in the school leaving certificate shall be treated as correct date of birth and not the same will not be altered under any circumstance. It's correct. But for that, he is to submit that the school leaving certificate that he didn't submit at that point of time. First, second, my lord, kindly see why, if this condition is not fulfilled, what happens there then?
No, but the school leaving certificate petitioner has, because this is a
He
school
might
leaving
have, my lord.
certificate of
I will come to
1993.
it. I will come to it. 1993 is coming. I may have a document of 1950. Now I didn't produce it in 1960. Now I come and say I have a document of 1950, but it does not prove that I submitted in 1960. My lord, that he is to prove. First of all, my lord, there are various other points, my lord, which I have to agitate before your lordship, my lord. Now,
May I just answer to that point also? One.
Just a minute, let me.
So, my lord, what? For that, my lord, what we had to do, that then instead of clause A, implementation instruction number 76, then clause B is
So
to be
according to
inserted.
you, the school leaving certificate was not submitted at the time?
Not at that point of time. Apart from the other points, I do have, my lord. This is as it has fallen. The question has come from your lordship, my lord. So I am answering, my lord. So we made his medical test, age assessment. We have to do, my lord, under clause B of this implementation instruction number 76.
Clause B.
Clause B, my lord. Kindly see.
Review.
Kindly see. Review. Stroke. There should be a stroke. Determination of date of birth in respect of existing employees.
Oh, review
Also,
then stroke.
All existing employees, and
Review then
before that,
stroke.
yes, then
Yes.
stroke, and before that, my lord, kindly come to clause 4. Illiterate. Illiterate. A4. Illiterate.
Where review A, B, then
The
A.
before that, my lord.
Illiterate, yes.
Illiterate. In the cases of appointees not covered under the foregoing clauses, the date of birth will be determined by the colliery medical officer, keeping in view any documentary and other relevant evidence as produced by the appointee. Date of birth as determined shall be treated as correct date of birth, and the same will not be altered under any circumstances. That's why his age assessment was done. And he himself had signed the Form B where this age was written. Form B was signed. I will show, my lord. He has not annexed those documents. Those documents are with me, my lord. I will produce it, my lord. He has signed Form B. There are various other documents. His appointment letter. And so far, his letter, first letter, which he is saying that in 1995, immediately after his appointment, right now we are denying that it was given at that point of time. Right now, my lord. Even if we say that yes, it was given, even if we assume, so for all these long years, he didn't do anything. From
No,
his
he is
letters,
submitting that he is making applications one after another.
no, it's not that. He is to show. He must.
When you first made application for
That
collection?
we are denying that.
Hi,
Now let him show.
Malas,
After
if-
that, when
Malas,
did he
if
make
he's-
that?
Malas, if it's correct that I have not submitted, my case goes. So let me first, Malas, satisfy.
No, show me first when you made application, because you were appointed
1995, 13/4/1995.
Just a minute.
Page 23, appointment letter.
Yes, then after that, when in your appointment letter, date of birth was written and date and the age was also stipulated.
Yes.
After that, disputing your date of birth and age, determination of age, when you first approached the authority.
Plus page 31. That is just 13/3/8/1995. Malas, this is Malas, a typed copy is given in page 32. And Malas, if your lordship sees at the Malas, first Malas, their endorsement is given. So Malas, this has been submitted and they have endorsed.
Just a minute. But there is a prima facie case.
He says, my lord.
Submitted a letter on 3rd of August 1995.
He says, we deny.
And
Then file your affidavit.
And Manoj, just one.
Because even otherwise, if as your lordship was rightly pointing out, my lord.
Because he was appointed.
My lord, kindly see.
Appointed in 1995.
2 months thereafter.
30th April 95, and then on 3rd August 1995, we raised
3 months.
dispute.
It's his contention, my lord. Kindly see the next date of the next letter. Even I assume that it was correct.
And referring to the school living certificate, stating that 25th January.
School living certificate was submitted. There is no proof, my lord. I am only referring to this document of this 1995 letter of him. And now, my lord, kindly see the next letter. When did he submit? Kindly see. And what did he write in that letter? It will clear everything. The very next page, my lord, page 33. The letter dates back to only 2021, 15th of
33.
Very next page is 33, page 33.
32.
32, and the very next page is 33. 15th of February 2021.
Yes.
So in between 95 and 2021 is nothing. He says that he had gone continuously writing, he had been writing continuous letters. There is no such proof, my lord. In that particular letter, my lord, if your lordship kindly sees paragraph 2, that while submitting the attestation form, itself is clear.
Yes, 25th January 69.
He said, what he said, my lord? I mentioned my date of birth as 25th January. I may mention anything, but if I cannot prove, cannot produce any document as to the proof of my age of my date of birth, then assessment is to be made. Age assessment is to be made. He says, I mentioned my date of birth as 25th January 1969 as per my school living certificate issued by Guru Nanak High School, Asansol on 9/7/1993 prior to my appointment. This school is a government recognized school under West Bengal Board of Secondary Education, copy enclosed. So it means he mentioned it in the attestation form. Copy was not enclosed. Now he's enclosing the copy here.
Previously, this was not submitted.
Not submitted. His own statement, paragraph 2. As your lordship was correct, my lord, there are several judgments. I have also 2 judgments, my lord, one of Supreme Court, another of the Honorable Coordinate Bench. Says some facts, similar facts, my lord. Let me file my affidavit, my lord.
Copy enclosed, but he has stated that he relied upon this certificate.
No,
at the
he
time
has
of
not said that.
appointment.
It is his statement. But paragraph 2 shows that he said that I mentioned. I have not submitted. He has not said that I had submitted. He has said that I have mentioned.
This is
no, my lord. This is the case, my lord. For all these long years.
File your affidavit.
Yes, very well, my lord. Even I have the judgment, my lord, with me. As your
At
lordship
this
was-
stage, it is not.
No, it's not required. That's why I'm not producing.
The problem is you ought to have approached this court much earlier.
Yes.
Manoj, yes, that definitely.
1995 appointment. You have filed this writ petition 2025 just before your retirement.
Manoj, I
So that you can work some more time, for some more time.
Manoj, there are judgments of the Supreme Court which says if I rely on mutual in a internal mechanism, that is also justified. And all the judgments of the Supreme Court, this honorable court division.
I have the judgments regarding these coal companies.
Manoj, I have also.
You have to prepare the-
Petitioner was appointed affidavit of service.
Yes, ma'am.
Affidavit of service filed on behalf of the petitioner is taken on records. Next paragraph. petitioner was appointed under Eastern Coalfields Limited, within bracket for short ECL, close bracket, VDA appointment letter dated 13/14 April 1995. And in the said appointment letter, date of age of the petitioner was assessed as 28 years based on date of birth 17 June 1994.
No, my lord, it was the date of assessment of age. Medical assessment.
Date of birth of the age of the petitioner was assessed 28 years. আর কিছু লিখো না। On 17th, as on 17 June 1994. In terms of the assessment made by the medical officer. Stop. Petitioner prays for correction of his date of birth. As well as age as recorded in service as recorded in his service records based on transfer certificate dated 9 July 1993 issued by Guru Nanak Mission High School, wherein it is stated the date of birth of the petitioner is 25th January 1969. Stop. Next paragraph, learned advocate representing ECL has opposed this writ petition, and he has submitted that transfer certificate was not produced at the time of appointment of the petitioner, as a result whereof medical assessment was made in order to ascertain the date of in order to ascertain the age of the petitioner. Stop. Moreover, next paragraph. Moreover, it is also stop. Moreover, it is also submitted that after. Moreover, it is submitted that. Moreover, it is submitted that present writ petition has been instituted just prior to his retirement. When he is scheduled to retire?
16th of June 2026.
Yes, ma'am.
16 June
2026, this year.
2025.
2026.
16, just prior to his retirement on 16 June.
Yes.
On 16 June 2026. Therefore, same is not maintainable. Next paragraph. Since factual aspects are required to be considered, ECL is directed to file an affidavit in opposition to this writ petition by 2 weeks from date. Stop. Affidavit and reply thereto, if any, be filed by 1 week thereafter. Next paragraph. List the matter under the heading hearing in the monthly combined list of March 2026.
Still then, Manoj.
Yes?
If there is an interim order, Manoj.
No, sorry.
Manoj, then at least, Manoj.
Nothing.
Because Manoj, not Manoj, if your lordship kindly fixes a date, Manoj.
Nothing.
Just kindly fixes a date.
No, sorry.
Because Manoj, if it not comes, Manoj, I will be retired.
You have filed a writ petition after being appointed in 1994 in 2025.
There
What
was
can
no
be done?
rejection. There was no.
No, sorry. I cannot pass any interim order relating to date of correction of age.
Plus, they have rejected it on 2025, saying that there is a delay. After, before that, there was no
Maybe.
letter. There's.
But after the letter was submitted in 1995, you sat tight over the matter and you have filed the writ petition in 2025.
Malas, there are judgments of the Supreme Court which.
Please call the next matter.
Item number 62.
The non-payment of the family pension of the deceased employee of the Calcutta Street Transport Corporation. My lord, on earlier occasion, my lord has given liberty to my.
Just a minute. When the petition is-
একটা রিপোর্ট দিতে বলেছিল disclosing the amount payable to ফটোকপি আছে order.
Yes. What is your instruction?
There is a code because Lordship's desire was to so that she can refund and get back. My lord, we have calculated. I've given my learned friend a copy also.
এক্সট্রা কপি আছে রিপোর্টের
No, তুই দিলেন না বাবাকে ধরো। দিয়ে দিতে হবে।
So you have to refund total 76,951 along with interest.
No, the amount.
Total is 1,69,153. Yes,
Total amount I have to.
1,69,153.
153 towards the employee share of provident fund along with interest and excess gratuity which was paid to me. Your lordship.
Only thing is provident fund.
Provident fund and excess gratuity.
Excess gratuity.
No, and as such the excess amount of rupees 76,951 was paid to him. Rupees 92,000 and odd was accrued as interest on excess amount of gratuity.
The total amount.
But gratuity petitioner is entitled to even if switched over from contributed provident fund to
GPF.
general provident fund.
জানিস কিছু? হ্যাঁ, বললি কি করে? ওটাই দেখলাম।
Only thing is
I followed your lordship. I followed your lordship.
I think there is a mistake in here.
Appears so because
Because
provident fund is fine. Gratuity amount should not. be
Was paid 164,814 towards gratuity.
there. That's right.
Under Payment of Gratuity Act, accordingly, DCRB regulation, he may be entitled to an amount of 87,863.
Right.
That was under the General Provident Fund.
General provision.
He was entitled to receive 87
Yes.
towards gratuity. Now, as per
No, this Malad, I think he tries to say that he was entitled to 87,000 and odd. He has been paid 1,64,000 and odd. So therefore, the calculation is that
this is principal amount is 76,951.
yes,
And interest is for the period from 2005 to 2025 and 92,202.
yes. The total comes to the 169.
Yes.
So how much I have to refund towards?
169,153.
Only 169,153 I have to return, and in return they will release my family pension after I return the amount. So they will release my family pension and the arrear pension, arrear family pension, and the original pension.
Pension from the date following the date of your return.
Yes.
From the date
Following the date of retirement of your husband.
my husband, that is my original pension of my husband, and my husband expired in 2007. From 2007 onwards, I'm entitled to get arrear family pension also. So, Your Lordship, that will do, Your Lordship. Within 4 weeks, I'm ready to refund this. After 21 years, I'm getting my pension. Your Lordship, anything, whatever my Lord will fix the amount and the date, I am ready to refund the same. 1,69,153.
But one thing is troubling me, Mr. Bihani, that whether the gratuity is required to be refunded. Because if the petitioner is under the contributory provident fund scheme, then the provident fund, excess provident fund is required to be refunded along with interest. Along with interest. But how gratuity is calculated? Because if a person is under the general provident fund, including pension and gratuity, then he is entitled to get gratuity also.
But I tell you, Lordship, the calculation I have not gone into. I have just been handed this over. I have not.
So, after passing an order, there may be a complication, obtain instruction and come back.
Only to that. The other things are fine. Principally, we are agreeable to give it
So the
back.
difference is only so far provident fund is concerned, and the service is not pensionable.
Service is
If a retired person is under the contributed provident fund, but gratuity is.
Because I frankly, my lord, I have not gone into this thing.
It's not a pensionable charge.
It is not a pensionable.
One-time payment to be made towards
That's
provident
right.
fund
That's
and
right.
gratuity.
That's right. Because, my lord, I also do not want that she will be paying extra.
So get a clarification and
She will
come
be
back.
paying
I'm just
extra.
adjourning the matter for 7 days.
Because she should not pay extra if not required.
Otherwise, the order which is to be passed today, that will require further correction.
Further, my lord,
Clarification.
Lordship will finally decide.
Yes, you take it back, get a clarification, and then
File afresh.
apprise this.
File afresh. I'll file another.
Yes. I'm simply adjourning the matter for 7 days. Hearing of this matter is taken up for consideration. Matter is taken up for consideration in presence of learned advocates representing the petitioner, state respondents, and Calcutta State Transport Corporation. Stop. Mr. Bihani, learned senior advocate, has prayed for accommodation to obtain a clarification relating to the amount which is required to be refunded by the petitioner for receiving pension. Stop. Hearing of this matter stands adjourned for 7 days. Or hearing of this matter stands adjourned till
today is 8.
15th January
16th. Subject to 15th, I'll possibly have some difficulty.
16th, there will be difficulty because of this inauguration and other things. Very well, let it be up to 16th. 16 January 2026.
Much obliged.
You also obtain instruction, Miss, that if it is employee is under the provident fund scheme, whether is entitled to get gratuity.
It's under GPF, General Provident Fund. She is entitled to get the this pensionable gratuity and the only the employee share of provident fund. And if is under CPF, then employee both and the gratuity under the payment.
So gratuity is common.
Lordship, gratuity is common.
But I will take interest. She had agreed to 1,69,000, so she cannot take interest.
No, you take in.
No, she had agreed for
It's a
169.
defective order.
1,69,000.
No, once she has agreed 169, she cannot take any more interest.
No, not that. Grateful.
I'm appearing for the petitioner.
Item number 63.
I am appearing for.
For the state government.
Give to 2 years.
Well, this matter will come to page 90. I am challenging
Petitioner.
petitioner. He retired from the court of the Chief Judge CBI Court 1 as a Serestadar. Now, my lord, upon coming of the recommendations of Shetty Commission, I prayed for that benefit.
You
Prayed for that benefit, my lord.
which benefit?
Under the Shetty Commission, benefits were given under the Shetty for upgradation of pay scale. I claim that now they are said that at that point of time when I was working, CBI was not at all under the CC Settlements division, so I am not entitled to. What is the reasoning, my lord? I do not know. But my lord, I will show from the documents. I have worked. My appointment was by the Chief Judge, and I have worked also parallelly in this post in other in the city.
Any decision is taken regarding your
Yes,
claim?
yes. My lord, decision. My lord, I was just going through the recommendation sent by the page 90, my lord. This is the recommendation sent by the Chief Judge Judge to the Secretary Judicial Department. Here, page 90.
90.
May I read it out, my lord? 90, my lord.
Yes.
This is the second recommendation, my lord. First, I am not showing because same recommendation. Apropos of above, this is to communicate to your good self that Sri Tarun Kanti Das, the petitioner, my lord,
Yes.
was appointed on promotion as Sherestadar UDC at his option in the then newly created Special Court for exclusive trial of CVI cases at Vichar Bhavan, Calcutta on 16/7/2008. In the scale of pay of 8,850 Ropa 1998 by virtue of the order bearing number 140 dated 11/7/2008, read with order wide number 148 dated 28/7/2008. Both passed by erstwhile learned Chief Judge, kindly similar. Both passed by the learned Chief Sessions Court, Calcutta, in terms of order of the Judicial Department, wide number dated 12/7/2004, passed in concurrence of the Finance Department, wide their UO number 1034, Group L, dated 26/2/2004, along with Cabinet approval wide number 911 dated 25/2004, and another order wide number etc. dated 6.
So from the date of your joining on 16 July 2008, you are seeking consolidation of your pay from 13,500 to 15,600 to 42,000.
Yes, ma'am.
That is your prayer.
Yes, ma'am. Now, my
So what is the basis of that claim?
No, this is on the basis of the kindly see the heading dated the GO number 22, judicial dated 24/1/2020.
You have retired in the meantime.
I am retired.
When you have retired?
2016, my lord.
And thereafter you have filed this writ petition in 2025.
No. This is a subsequent development, my lord. Shetty Commission recommendation, my lord. They are being implemented subsequently, my lord. So I am entitled to that.
When this City Commission recommendation was implemented, according to you?
Memo was no, my lord, 8 no. City Commission recommendation ta jeta.
The rule to ye cheta.
At 78, page 78. It came into force on 24/1/2020.
Yes, what is the stand of the state government regarding
Well,
the recommendation of city commission?
Well, they
Mr.
have said
Mukherjee,
Can you see page 85?
93 also.
what is the stand of the state government regarding implementation of city commission?
City Commission recommendation rules have been framed according to the approval granted by the state government. But first draft rule was framed by the High Court administration. Then there are certain corrections were made. Then after, according to the order of this Honorable Court, government approved it, notified in 2021.
So then, in that event, pay scale of the petitioner is required to be revised.
No, not, there has not been retrospective effect.
No, show me that it has got no retrospective
that is
effect.
not the-
That is the crux of the issue.
That is not
No,
the
no, page
reason.
85,
They are
page
saying-
85, page 85 for a moment. 12 March 2022.
May 2022, just in.
May 20.
এটা কোনো annex করেন নাকি? 6 July 2021. এই তো City Commission recommendation.
So amalgamation was made on 31st January 2019. Prior to that, you retired on 31st of May 2016.
So it is
So
not-
how you are entitled to?
I'm showing that. It is not an issue of retrospective effect because Lordship will kindly see 95, page 95. I have been in 2024, I am being given benefit when I was in the municipal magistrate court. That benefit I am being given. But here I am being denied because they are saying it was not amalgamated. Your
Yes.
Lordship has seen the recommendations. It was kindly come, my lord, see when the city the formation of the special court, everything is been done by the orders of the chief judge. My appointment has been given by the chief judge, and not only that, I was parallelly discharging duties in
No,
the.
you show me from the recommendation that even if there is no amalgamation and you are entitled to get the benefit of recommendations of city commission. It has got no, it is from the retrospective
No,
effect.
recommendation is mine.
It has retrospective effect. You show me
Recommendation is in my favor, my lord. Kindly see.
where is that?
Recommendation by the chief judge,
Chief judge is
not by the
recommending
state
my
government.
Chief judge.
Where is that recommendation?
Well, page 90, my lord. The one I was referring to, my lord.
Page
90.
90.
Since my last paragraph. Second last paragraph. On careful perusal of Geo 22 JDL 2S4 dated 24/1/2020, it is revealed that post of Shirastada, Senior Shirastada, Chief Administrative Officer have been situated to Court of Civil Judge, Junior Division, the Civil Judge, Senior Division, District Judge, respectively. And the benefit of the elevated scale of pay of Shirastada, its counterpart had been extended since 1/4/2003. Since Sri Tarun Gandhi Das was appointed and performed his duties as Shirastada in the Special CBI Court number 1, City Sessions Court, Calcutta, a court presided over by a judicial officer in the rank of additional district judge, Sri Das may be granted the benefit of scale of pay of chief administrative officer, that is 8,275, 13,500, since revised to scale of pay of 15,600, 42,000 plus grade pay of 5,400. with effect from his date of joining in the post, that is 16/7/2008. And this was
Now,
in
if
this
it is from 1st of April 2003, second paragraph of the recommendation of the Chief Judge Sessions Court, it is stated that the benefit of the elevated scale of pay of Sessadar and its counterparts has been extended from 1st of April 2003. Then why the petitioner will not get the benefit?
No, can you see? The post of special CBI court were created in 2004 and the said court started functioning in 2005-2006. Torun Das had been holding the post of
Where from your first paragraph?
page 93.
Page 93.
Yes,
Just
government decision. The post in special CBI court were created in 2004 and the said court started functioning in the year 2005-2006. Sri Torun Kanti Das had been holding the post of Solicitor in the cadre of EDC in the CBI court and retired on 31st May 2016, whereas the establishment of special CBI court has been amalgamated with the City Session 7 court with 31st March January 2019, so Das is not eligible to get benefit due to such amalgamation. Amalgamation is
amalgamation is relevant. If the petitioner was working as a solicitor in CBI court, why his right to get the benefit of city commission recommendation will be there?
No, High Court has not protected. High Court has not protected when framing the rules.
How?
According to the City Commission's recommendation, rule was framed by the High Court in 2021. That was published on 16th of July 2021.
Show me that rules.
I have got a soft copy.
My lord, can you see one thing?
No, that rules are to be seen. If High Court has framed rules in terms of the recommendation of the City Commission, that has to be considered. What are the rules of our court relating to implementation of City Commission recommendation needs to be considered. ওটা দিও না বাবু, দাও অসুবিধা হয়।
I just wanted to say a few things. My appointment was with the chief judge. My appointment was with the chief judge. This was a sanctioned post where he was made the government made the chief judge the appointed authority. All throughout my career, the chief judge was my appointing authority.
If you are praying for consolidation of your pay scale from a retrospective effect, with effect from 16 July 2008, show me supporting provisions. Matter ends.
Provision, my lord, I am only on the challenging only.
That is what I want.
Only this line.
Mere claiming will not do. Show me the supporting provision.
My lord, their rejection is on the basis of that he retired on whereas the establishment of CBI court has been amalgamated with the City Sessions Division.
No, I just the exact question which I have asked to Mr. Mukherjee. He is saying that this decision is taken in terms of the rules of High Court. So from the rules of High Court, you demonstrate that I have the right. Matter ends.
Well, I have to see the rules if the rules have given this power, my lord, because
where is that rule? Show me that rules.
Well, I was arguing on
otherwise on what basis court will come to derive a finding that you are entitled to get the benefit?
Well, I have shown one document that I have got.
Mere recommendation of the
recommendation.
Chief Judge is not sufficient.
No, page 95, my lord. I have been given in my previous when I was in municipal magistrate court. Same logic applies, my lord. This
page 95.
95. This is 4 July 2024. In terms of resolution, City Commission implementing of the under mentioned employee promoted to the post of subordination in scale of pay. I have given retrospective promotion. My name is at item number 3. I have been given benefit. Item number 3, my lord. My name appears at 3.
But it appears that it is after, as per ROPA 2019. Page 95.
My lord.
It is as per ROPA 19.
Yes, my lord. No, SETI commission recommendation. ROPA is the scale, mentioning the scale, my lord. In the scale of pay under rules, ROPA rules 98. In terms of resolution of SETI commission recommendation implementation committee.
Please read it. Read it.
The under mentioned employees are promoted to the post of upper division clerk in scale of pay of 4,000 to 8,000 under WBS rules since revised to pay band 3, which is 7,100, 37,600 plus grade pay of 3,600 as per ROPA since revised to pay level 9 under pay band 3 as per ROPA 2019 with retrospective effect from the respective day as mentioned in the names of the table below. 3, Torun Kanti Das, date of effect is 1/6/2007. Much before I was appointed in this higher post. Their objection is
Now it was date of effect was 1st of June 2007.
Effective date.
What is the date of your initial appointment?
Initial appointed 1990.
1990. Now, in terms of page 95, when this effect was given, 1st of June 2007.
My lord.
1st of June 2007.
2007.
Now, this was withdrawn subsequently.
No. I am saying, my lord, their reason for denial is a very flimsy.
No, when it was given, then where is the question of further extension? So far, the facts are concerned. These are not clear to me.
No, it is not a question of extension. One benefit I am being given.
That is from 1st of June.
This I have been given. This is I was working as the upper division clerk in the municipal magistrate court.
Yes. Then if it is given, then where is the question of not granting this benefit?
This is a subsequent benefit. Another benefit is given. This is a subsequent one. This is 2024. That benefit came in earlier. I have been rejected. That has been rejected only on a ground that he did not belong under the cadre of the city session division. City session division, they are saying, was formed, amalgamated. It was a separate division, they are saying. It is their submission.
Yes, that is.
So my lord, if
that is page 85.
If city sessions division, if it is a different division, my appointing authority is the chief judge of the city sessions court. How can I be denied? How can I be denied just because there was a different, separate division? Same appointing authority, my lord. Can you try to understand? It is the same appointing authority.
There was an enhancement of scale of pay from 1st of June 2007.
Yes.
In terms of page 95.
Yes.
Now, thereafter, you enjoyed the benefit under the recommendation of City Commission. Then where is the question of further extension of benefit in terms of City Commission recommendation?
That is in respect of my promotional post. This was previous.
In the promotional post, though that benefit was not given to you.
No, only on the ground that this was not. This was a separate division. It was not within the city session division. Only ground, my lord. No other ground. Now, I will show my appointing is appointment transfer. Everything has been done. He was made the appointing authority. Now, how does it matter if it's a different division or not? Because head of the city session division is the chief judge. And I will also show letters where they have been tagged together. And in addition to that, I was discharging duties of the city sessions court. Kindly see. Page 39, na? অ্যাডিশনাল চার্জ কোথায়? অ্যাডিশনাল চার্জ যেটা
39
এখানেই আছে। মাইলর কাইন্ডলি সি পেজ 39.
But Mr. Mukherjee, once this benefit was given to the petitioner, as it appears from page 95.
But for 2022 order, page 85. He has accepted.
Page 95, come to page 95.
Yes. This is in regard to the promotion to the upper division post. But he's asking as a special pay for holding the post of Saraswati in a CBI court. Two different things. CBI court is a different. And other courts.
Why CBI court will be different?
But CBI, he is asking for a separate.
No, I'm asking you why CBI court is a different.
Because different CBI court is a specially designated court by this honorable court.
So what? But he is working as Saraswati, he will not get the benefit under the recommendation.
No, that has not been given retrospective, but the High Court could have.
Then how petitioner was granted this benefit on 4th July 2024, page 95, with effect from 1st of June 2007?
Upper division clerk.
Yes. So for a period, for a limited period from 1st of June 2007, he was granted benefit. Subsequently, that benefit was not granted on promotion.
No, but
does it make any logical approach? Whether it is a logical approach?
Upper division clerk and Saraswati after the City Commission recommendation.
Come to page 95.
Yes, no. In terms of the resolution of the City Commission recommendation,
as it appears that the recommendation of the City Commission was implemented with retrospective effect.
Yeah.
Yes. As a result whereof in 2024 it was granted from 1st of June 2007.
Yeah, but I can't see the language.
Yes, that is page 95.
In terms of the resolution of the City
page
Commission,
95, that is the dated 4th of July 2024, and benefit was given from 1st of June 2007.
Mentioned employees are promoted to the post of upper division clerk in the scale of which 4,000 to 8,050 under Ropa Rules 98 since revised pay band number 3, grade pay rupees such and such, with label number such and such, payment with retrospective effect in the mentioned below. Torun Kanti Das from date of effect 1st of July 2007. Date of vacancy 1st June 2007. But he has been given benefit.
Therefore, on promotion, that benefit was not given.
No, he has been given me the.
Give me the chronological dates. That up to which date you got the benefit in terms of 4th July 2024 order. And thereafter, when this from which date on promotion this benefit was not granted?
From 2008, my lord. This is my appointment letter. Kindly see page 35. I'm claiming from this my appointment.
Kindly see the recommendation of the rules framed.
Kindly see my appointment letter. This is my first appointment letter.
On promotion?
No, on
page 35.
It was a fresh promotion. A post was created. I was in a promoted post. Page 35. This is 3/6/2008. Page 35.
Yes, 35.
Appointment for the post of Shirastadar UDC, newly created special court for exclusive trial of CBI cases at Vichar Bhavan. Option is invited from Ministerial Serve, posted at UDC LDC in the West Bengal Government Service for appointment of post of Shirastadar in the above mentioned court, permanent basis on usual terms and conditions government employee, rules of government West Bengal. This notification in terms of Judicial Department memo number dated 12 June 2024. Rated 16 November 2020, issued with concurrence with the Finance Department, wide EO number 1034, Group L, dated 26/2/2000, and also the approval of approval committee of cabinet by approval number 804. Decision with ACC meeting held. The present posting will be at Vichar Bhavan, Calcutta, under the Judgeship of Chief Judge. Citizens Court, Calcutta. Such option must be reached. Inform all. Kindly see who is signing City Session. Chief Judge City Sessions.
Chief Judge City Sessions Court.
Next also. And also can't come to see.
And your order says page 85.
85.
Just a minute. It says that a post of special CBI court were created in the year 2004 and that the court started functioning from 2005 2006. Torun so had been holding the post of Saristadar in the cadre of UDC in the CBI court, and he retired on 31st of May 2016. Whereas the establishment of CBI court has been amalgamated with City Sessions Court Kolkata on 31st of January 2019. Can you say this in view of page 35? The present posting will be at Bichar Bhavan, Calcutta under Judgeship of Chief Judge City Sessions Court, Calcutta.
Further, one more.
Just a minute, please.
Kindly see page 25, his first appointment.
That is 30th June 2008 order. And you are saying by an order dated 12th May 2025 that the last line in is of the second paragraph is significant, that the establishment of CBI court has been amalgamated with the City Sessions Division, Kolkata, with effect from 31st of January 2019. So she does
Before
not
amalgamation,
eligible to get the benefit arising due to such amalgamation. But his very appointment was as Saristadar was under the chief under Calcutta under judgeship of Chief Judge City Sessions Court.
Before amalgamation, he retired. He retired in 2016.
That is 3rd June 2008 order. Come to page 35.
Yes, 35, yes. 35 is the initial appointment.
Yes.
No, prior to the page 26 is the initial appointment.
No, please come. I am not initial appointment. I am on his appointment as Saristadar under Chief Judge City Sessions Court.
Yes.
Come to page 35.
Yes.
Last paragraph, page 35.
This present posting will be at Bichar Bhavan, Calcutta under the Judgeship of City Court. Calcutta, such option must reach the undersigned by 30.
So where does question of amalgamation would be can be a ground, or how the question of amalgamation can be treated as a ground to deny such the benefit for higher
He
benefit?
wants a post of special pay or pay scale of Saristadar in a CBI court, not as a Saristadar in other court.
No, it says that his very appointment was under the Judgeship of Civil Judge City Sessions Court.
Option is invited from Municipal Ministerial Staff Area, West Bengal, for appointment of Saristadar in the above mentioned government on permanent basis on usual terms and conditions government employees under the rules of government such and such. Issued with the Congress Department and also with the approval of the appointment committee. Bichar Bhavan, then Manap.
Present posting will be at Bichar Bhavan, Calcutta.
Calcutta.
Under the Judgeship of Civil Chief Judge City Sessions Court, Calcutta.
Judgeship of Calcutta.
And your authority is taking a decision that these posts of special CBI court were created in the year 2004 and the court started functioning to the petitioners holding the post of Saristadar in the cadre of UDC in that CBI court, and he retired so and so, whereas the establishment of CBI court has been amalgamated with the City Sessions Division, Kolkata on 31st January 2019. There may be an amalgamation, but his appointment was in terms of under the Chief Judge City Sessions Court. So why he will not get the benefit?
But Saristadar in a civil court or Saristadar in a CBI court, there are two different posts. Then Madam allow us to file an affidavit. We shall have to justify this order. Page 93. Huh? But a post of Saristadar in the CBI court and post of Saristadar in the civil court, we are two different posts, different cadres created by.
But for that, on that basis, whether any discrimination can be made in the matter of granting pay scale, under the recommendation of city commission.
Provided there is a recommended approval by the government. He is recommended approval by the cabinet committee in a civil court, not in a CBI court.
Yes, but his very appointment in 2008 is under the Chief Judge Sessions Court.
Chief Judge Civil Court. Chief Judge Civil
Why
Court.
his pay scale will be denied?
No. Chief Judge Civil
So
Court.
therefore, by getting promotion, he was penalized.
No.
Previously, he was getting.
He ought not to have accepted. He ought not to have accepted this because I am holding the post of Sadar in a CBI court. Give me the approval of the CBI court. I could administer.
Getting the benefit from 2004, and that was not extended after on promotion from 2008.
But High Court administration.
The chronology of facts.
High Court must give a reply to this.
I have not even shown the subsequent documents, how they have conducted. Everything is done as if it is the same body.
But why you have not made High Court party?
High Court is a party.
I have made a party.
High Court is party.
Yes.
Party. কে আপনি appeal করেছেন?
কেউ অ্যাপিয়ার করছে না রেজিস্টার
High Court administration is party.
I'm appealing for Chief Judge.
Stand of the High Court is also necessary.
Respondent number 4.
I'm appealing for respondent 5, 6, and 7.
Chief Judge Citizens Court.
Well, Chief Judge Citizens is supporting me, my lord.
Yes, because
They have recommended mine.
I've recommended all.
yes,
That is
made recommendation. Mr. Mukherjee is opposing based on this page 95.
The
Page 85.
Respondent number 4.
Thereafter,
Register
I have been given additional charges.
Because
Additional charges
every
as
circular and notification lying with the
Survey notice upon the Register General High Court Calcutta, respondent number 4.
Right.
Let me consider and give a short list, not list of dates or chronology of facts.
Yes.
That will help this court. Issue.
Well, affidavit service skip.
In the writ affidavit service filed on behalf of the petition is taken on record stop. In the writ petition, memo dated 12th May 2022 issued by the Joint Secretary to the Government of West Bengal. Judicial Department is questioned whereby petitioner was not granted benefit of highest scale of pay.
High Court হয়ে আসুন কি বলে দেখি
Stop. Matter is heard at length in presence of the learned advocates representing the petitioner, state respondents and respondent numbers
5, 6, 7.
5 to 7. Up to 8.
5, 6, 8. I see that.
Respondent number 5 to 8. 5 to 8.
No. 5, 6, 7. Oh.
Respondent 5 to 8. However, High Court, Registrar General, High Court Calcutta, being respondent 4 is not represented. Next paragraph, considering the issue involved in this writ petition, court desires to hear High Court administration. Next paragraph, learned advocate representing the petitioner is directed to serve notice upon respondent number 4, enclosing copy of this order by 15th January 2026. Hearing of this matter stands adjourned till 27th January 2026.
7 January. Or 15.
No, every report.
No, not at this time. Nothing.
Administration has to clear to look.
No opposition at this.
There is several notification also there. Not